right, we'll go on record on the court's afternoon docket on Monday, January 26th. And the first matter the court will call, we want to start with Mr. Hunter, is that correct?
Yes, Your Honor.
All right. We'll call file 25-10199FH, People State of Michigan versus Kemper Allen Hunter. And Mr. Hunter, I see you there via Zoom from jail. Can you hear me all right? All right. This matter is on the court's docket, I believe, for a plea. Is that correct, counsel?
No, that is not correct, Your Honor. I'm requesting a motion to adjourn in these two files. We currently are working on obtaining some, identifying some witnesses that we believe may be necessary for the defense, and there's an original file, an older file, where it indicates, I believe, that he has a pending charge of larceny of $1,000 or more, but less than $20,000 as a habitual fourth offender notice. On that file, Your Honor, and the other file that we also have potentially set is a drug case, Your Honor, and on that one, I am just finalizing a motion for suppression regarding some of the information I think is necessary to be heard by the court prior to a jury trial on that, Your Honor. And we've been working with the private.
Okay, and who's handling this on behalf of people? Attorney Stecker, I see you there.
I am, Your Honor.
Okay. Is there some reason, obviously I would assume that we wouldn't hear both trials at the same time. Is there some reason we couldn't proceed with the larceny file, even though there are motions on the underlying on the other matter?
Your Honor, I just heard from the defense attorney that he's looking to see if there's other witnesses for that particular case.
That's correct.
It was our intention based on the discretion of the prosecutors in which case to go forward with. We were to go forward with the possession of an case first trial.
And Your Honor, just to be clear, I'm only asking for a short adjournment regarding the drug case at this time in hopes of getting that suppression motion put in front of the court very soon.
I can't translate into Holmes.
Sorry.
Your Honor?
Yes, go ahead.
And once again, if the court does grant the adjournment, I do agree. I would like to move this within the next 2 to 3 weeks on the possession of methamphetamine case. Pending his motion.
All right, Attorney Hoag, we're scheduled for trial tomorrow, and you're asking that both matters be adjourned?
Yes, that is correct, Your Honor. In the initial one, again, the older file is the one that's indicating it's a larceny, the habitual.
That's the file 2510151.
Yes, and on that one, I'm working on identifying or locating some potential key witnesses, Your Honor. And again, that would be in that file, yes, Your Honor.
And then what about the 2510199, which is the possession of methamphetamine case?
That one, Your Honor, I've been reviewing with my client and our private investigators some issues that we are seeing that we should address it through a suppression motion, Your Honor. That's the one that I am intending on having that file regarding some of the evidence that was obtained by the local law
Okay, so
enforcement.
that's the matter that you're looking at potentially filing a suppression motion on the evidence?
Yes, Your Honor.
Okay. All right, and then in the 10151 larceny case, you're looking at locating some additional witnesses.
Your Honor, the witnesses I'm trying to locate are I think if they're able to come forward, I think this case would probably dissolve and I would imagine the prosecutor would probably dismiss if these individuals would come forward. So I think that these are very key and crucial to my client's defense, yes.
All right, Attorney Snecker, your position?
Judge, we're ready, we understand his issue. Once again, if the court does grant the adjournment, we're asking the court to set this within the next 2 to 3 weeks for trial on the possession of methamphetamine case. That's the case we want to go forward on first, Your Honor.
All right, and then how long do you think you're going to need, obviously, to get a motion filed before the court in reference to the possession of methamphetamine 10199?
Your Honor, I can have a motion before this court filed by next Monday.
All right. Mr. Hunter, obviously you're in, this affects you. You're actually incarcerated right now. Your attorney, I'm sure, has discussed the matters with you. He's asking that I adjourn these matters and try to get him back on the court as soon as I can. I can't guarantee when they are. We have lots of trials set, obviously, but we'll try to get it set as soon as we can. Do you want to, are you in agreement with having this matter adjourned? I don't know what the, again, I'm sure you probably discussed the issues regarding the suppression, and obviously it's suppression of the evidence.
I mean, is there any way that, I guess I'm misunderstanding the way I can let you. Is there any way that I can speak to my attorney about this before I answer your question, Your Honor? Because I wasn't impressed that we had filed tomorrow, that everything was filed and all that. I haven't had a chance to talk to him. I mean, I'm not opposed to 2 weeks at all, I'm not, but I would like to just have a full, good understanding if that's possible.
All right, Mr. Holt, can we get you in a breakout room maybe with you?
Absolutely, absolutely.
All right. And Mr. Kemper, you take as much time as you want. I've got a full docket this afternoon, so make sure you understand everything with Attorney Holt. And when you're back on, he can come in the courtroom. We can get you back on Zoom, and we can get you back on the docket, okay?
I appreciate you. Thank you for your time. Thank you.
You're welcome. Yeah.
Thank you, Your Honor.
You're welcome. Let's see, we have Attorney Feldman.
Afternoon, Your Honor.
Good afternoon. Are you ready on Michael Pompey?
No, he is not here right now yet, Judge. I just messaged him. He is
All right,
not.
how about Christopher Leader?
He's in custody, Judge.
Okay, so obviously, Attorney Holmes, Mr.
I have a couple people here first. Candace Byrne, B-Y-R-N-E. Give me a spell that again, Judge.
No, I've got, is she on our calendar?
Yes? Oh.
25-10263 FH, people say Mission versus Candace Lee Byrne. This matter is on court side for a pre-trial hearing. We do have jury trial scheduled on May 19th, final settlement, April 24th. Do we have, has there been an agreement reached in this matter, or any offer been made for the record? And Attorney Stecker, are you handling the whole docket this afternoon, or?
Your Honor, I'm handling the non-drug cases. I'm here for this case.
Okay, Attorney Ronnie?
Yes, Your Honor.
All right, so you're on this matter then, so it's just pre-trial and there are no offense, any resolution?
There has been no resolution, Your Honor. There is no offer in this matter. We informed the defendant in district court that if she did not accept the misdemeanor offer in district court, that there would not be any further misdemeanor offers, and so there is nothing to convey at this time.
All right, Attorney Feldman, anything we need to address? You have all the discovery you need?
I believe I do, Judge. I just provided my client with a copy of the prelim, so she's had a chance to review that. We'll be ready for jury trial, and we will probably show up to the settlement conference just to make sure there's no last minute details.
All right, Ms. Burns, let me ask you, can you, we've got your address listed at 220 Conti Street in South Bend, is that correct?
Yes,
Okay, and what's the phone number if we had to give it you in an emergency?
574-807-4079.
All right, stay in contact with your attorney. We do have a jury trial scheduled May 19th. There's a final settlement conference date. That date you may or may not need to show up for. Keep in contact with your attorney in reference to that date if there's any resolution. If not, you'll need to be prepared and ready to go to trial at 9 o'clock in the morning on May 19th, all right?
Yes, may I request that charges are dropped?
Well, you can't request them from me. Your attorney could file a motion and the prosecutor could respond to that. And so, but that's something I can't do unilaterally here. That would require some kind of motion, potentially some testimony be taken, and then the prosecutor would have an opportunity to file a response to that motion or oppose it.
Okay, sir, thank you.
All right. With that then, Attorney Ronnie, anything further?
No, Your Honor. Thank you.
Attorney Feldman?
Nothing further, Judge. Thank you.
All right, Ms. Byrne will continue on bond as previously second, free leave courthouse.
Thank you.
All right. Attorney Feldman, anyone else that you have ready today?
I have Miss Thomas on Zoom, Brianna Thomas.
All right, we can go on record and file 25-10262 FH. People say Michigan versus Brianna LaKira Thomas, excuse me. And Ms. Thomas, can you hear the court all right?
Yeah.
All right. That matter is on the court docket as well for a pre-trial hearing. We do have jury trial scheduled May 19th, final settlement in that matter on April 14th. And Attorney Feldman, have there been any resolutions or Attorney Ronnie, any resolutions in this matter?
There's no resolution to date, Judge, but I'm scheduled to meet my client in the very near future. We anticipate being able to work this out.
All right. Attorney Ronnie, from your office, any requests?
No, Your Honor. I agree with Mr. Feldman that we're in conversation on this case, and I think that there will be an agreement. I think we just need to get the details worked out.
All right, Ms. Thomas, we've got your address listed at 176 Western Avenue, Ben Harbor, is that correct?
Yes.
Okay, and what's the phone number if we had to get with you in an emergency?
269
Okay.
298-7208.
All right, stay in contact with Attorney Feldman. If there's any resolution, he'll get you in the court prior to the trial date. If no resolution, you'll need to make sure you're ready, prepared for trial on Tuesday, May 19th at 9 o'clock in the morning, all right?
Yes.
All right. We'll go ahead, anything further, council, on this matter?
No, Your Honor.
No, Your Honor, thank you.
All right, we'll go ahead then and continue on bonds previously set. Ms. Thomas, you're free to sign off at this time, okay?
Thank you.
You're welcome.
Judge, I don't have anyone else here in person, and I can only see Ms. Littoral on the Zoom screen.
Okay. Ms. Locke, Attorney Locke, I see you there. Who are you here on?
That's Callie Locke from the prosecutor's office.
Oh, Callie, I'm sorry. Okay.
I do have Brittany Backus that I can see now. We're prepared to go on that PV, Judge.
All right, I see,
Brittany Marie.
I see Ms. Backus there on the screen. Can you hear the court all right, Ms. Backus? All right, we'll go on file, on record file 22-10159 FH, People State, Michigan versus Brittany Marie Backus. And Ms. Backus' case is on my docket today pursuant to a request and summons for probation violation that was filed by Agent Michael Morrison. I see Mr. Morrison there on the screen. Can you hear me all right, Agent Morrison?
Yes, sir.
All right. Ms. Backus, the request and warrant for probation violation was filed, was filed on January 6th this year. It was filed by your agent and alleges in count one that you violated condition 1 by distributing an intimate image, and that is a violation. Your probation agent indicates of condition 1 of your probation. Attorney Feldman, have you had an opportunity to speak with Ms. Backus in this regard?
I spoke with both Ms. Backus and Mr. Morrison, Judge. There's a pending case, a misdemeanor, down in St. Joe County, Indiana, with a court date on February 3rd. We would ask that a not guilty plea continue on his probation violation, be reset to sometime after February 3rd to see what happens down in Indiana on the underlying charge.
All right, and then Agent Morrison, after we've got some pending charges down there, so we'll not proceed with the violation here. Any specific requests that you have in reference to Ms. Backus as far as reporting or any further conditions on bond?
No, sir. She's reporting acquired. I've had any issues with her besides this, and due to come show her in the report.
All right. Ms. Backus, then we'll go ahead and continue on bond as previously set. We'll continue this matter until sometime after February 3rd. And then, do you have an attorney down in Indiana in this matter?
My first court date is on February 3rd, so it's just started. I just got paperwork within the last couple of weeks.
Okay, so you don't have an attorney assigned yet?
No.
Okay. What I would say is, why don't you, I'm going to set it a little farther out, Attorney Feldman, maybe like the 3rd week of February.
That's fine, Judge.
I'm due to have a baby February 23rd.
Okay, how about the 22nd? No, just kidding. But why don't we set it, I guess we can tentatively set it the week after. And if it's a misdemeanor case and it is resolved in Indiana, then you get with Attorney Feldman, make sure he knows the name of your attorney. And then if need be, we get the matter, even potentially get it scheduled if it is resolved in Indiana, even before you have your baby up here, okay?
Okay.
All right, just continue to report to Agent Morrison as directed, and we'll go ahead and see you back once this gets renoticed, all right?
Thank you, Judge.
Okay, thank you.
You're welcome. Yeah.
Your Honor,
Go ahead.
did Mr. Kaufman have Trevor Wallace for today?
I did.
Yeah, I just don't know.
I don't think he's.
He had to be, there had to be a writ issued from MDOC,
Okay.
so I don't see him, maybe we just staff, do we have any? Do we have, MDOC on with Mr. Wallace?
We do not.
Okay. All right.
All right, thank you, Your Honor.
Attorney Drake, do we have, Mr. Hatcher?
We do, Your Honor.
All right.
But we lost the prosecutor.
Attorney Stecker, are you handling this matter?
Your Honor, I'm sorry, what's the case?
Mr. Hatcher?
I don't have it on my docket, but I certainly can handle it.
Okay, well, it was just it's a bond violation, and it was on a DD third. It was a process, Attorney Drake indicated we lost the prosecutor, so I didn't know if you were handling it
No,
or not.
I'll be glad to handle it. I'm sitting right here, Your Honor.
All right, well, why don't we call file 25-10166FA, People State of Michigan versus Hugh Edward Hatcher. Mr. Hatcher's case is on the court's docket here on a bond violation that was filed regarding contact. It's a domestic violence third case, and it's alleged contact with the alleged victim in that case, Kelly Meacham. And that bond violation was filed actually by Berry County Sheriff's Deputy with the court on January 12th. So, Attorney Drake, did you have an opportunity to discuss the matter with Mr. Hatcher?
Yes, Your Honor, I did. I actually was aware of this earlier, but yes.
Okay. And in reference to the violation, again, I don't know what Mr. Hatcher's position is. Does he intend to admit the violation, or do we need to have some testimony?
No, there was some contact, Your Honor.
You said there was contact?
Yes.
Okay. And Mr. Hatcher, then, do you acknowledge that there was contact in violation of your bond conditions?
Yes. Yes, Your Honor.
Okay. I guess in reference to this matter, then, obviously, Attorney Stecker, I don't know what the position of your office is regarding the incident here.
Your Honor, if he's taken an admission, or I'm sorry, if he's admitted to having contact, then certainly we ask the court to take that admission.
Well, I don't have any problem taking the admission. I just, what is it that, do you have any recommendation regarding, what the court should do regarding the bond conditions? And I don't know, Attorney Drake, if you want to present anything to the court?
If I could, Your Honor, that might help everybody out.
Go ahead.
This involves an incident back on, I think, around about January 5th, maybe January 4th. I'm not exactly clear on the exact
I
date.
think it's the 4th, according to the document filed, it's the 4th.
And Miss Meacham herself had called my office to inform me, and she indicated that her car had broken down. She had contacted Mr. Hatcher, that Mr. Hatcher had come out, got her car running, and in that was, as they're all sort of, getting that squared away, was when they had contact with the Berrien County Sheriff's Deputy. Mr. Hatcher was arrested. He was taken to the Berrien County Jail. He spent 3 days in the Berrien County Jail, bonded himself out on a $2,500 cash surety bond, and has been out since. Obviously, he spent 3 days in jail on this matter. Berrien County actually thought it was from a Berrien County case, so there's a little bit of delay there until they found out it's a Cass County case. You know, he has trial coming up on the 4th, the 3rd? Yeah, the 3rd. And I believe, after speaking with Mr. Ronning, that they intend to proceed on the second file, the file with Casey, and not on this file. So I would ask the court to consider the 3 days in jail as a significant enough consequence for this violation, given the nature of it. It was not combative, it was not, you know, unwanted contact. It was initiated by Ms. Meacham. And I know that I've gotten a report from Ms. Smith earlier today saying that, you know, while Mr. Hatcher's been on pretrial supervision, with the exception of this incident, he has been in complete compliance with her and her check-in. So I think that given that we're in the home stretch on these files, I just ask the court to consider the 3 days a significant consequence, as well as the financial output that Mr. Hatcher had to do to bond himself out.
Looks like you had 3 days and had imposed $1,000 for bond, correct?
$2,500, yes, Your Honor.
2,500, okay. All right, Attorney Stecker, any position from your office?
Your Honor, yeah, I'm sorry, Jason Ronning, I'm in the courtroom now. I'm more familiar with this case, if I may take over.
Go ahead.
Thank you, Your Honor. Your Honor, I just want to indicate for the record some concern from our office. Mr. Drake is correct that the trial is next week, and it looks like Mr. Hatcher has been in compliance with bond conditions for the most part, except the issue we have is that's exactly what happens in domestic violence cases. There is obviously more than just the one contact, and now the victim is contacting our office asking us not to proceed after calling the police originally saying that she was attacked, and then there seems to be some sort of contact, and then suddenly there's a reluctant or non-cooperating witness. Fortunately, in the other case, we do have a witness, and we are prepared to move forward on that one. But I just wanted to voice our concerns for the record, Your Honor. When somebody violates a bond condition, it is a contempt issue. We would just simply ask the court to take that into consideration. If the court is going to allow him to remain out on bond without any further penalty, we understand. We would ask that the court simply remind him that those no contact provisions stay in place for both cases until they are lifted by the court. Thank you.
Thank you. And Ms. Smith, in reference to Mr. Hatcher, he's reporting to you as Attorney Drake's represented as he was supposed to?
Yes, Your Honor. He's been on supervision with my office since August of last year, so quite some time. He has checked in regularly as directed. He's appeared in court as directed. He actually self-reported to me this bond violation after he had posted bond in Berrien County and has kept in close contact with me. There was some confusion about where the case would land, that Berrien thought it belonged there. So he's been in close contact with my office and been very honest about this violation. I support the 3 days consequence and continued bond.
All right, Mr. Hatcher, then what I'm going to do is obviously based on you acknowledging your violation and the fact that you did spend 3 days, had to post additional monies on bond, I'll go ahead and determine that that's a sufficient consequence, but I want you to understand, obviously, it's not an excuse to come into the court. I'm sure you've heard that from Attorney Drake, that she's called you and asked for contact. When Judge Renfro issued those no contact orders, that means no contact. And if she were to contact you and say, my car is broken down, you're going to just need to tell her, call the police, call the tow company, call somebody else, but you're not having any contact with her. And that's what happens in these kinds of cases. You're the one that's on bond, you're the one that has the bond conditions, and it's not an excuse that a victim contacts you. So I think as Attorney Ronnie indicated to the prosecutor's office, you need to appreciate from here on out to not violate those conditions of bond, because it's not going to be an excuse if we come back in here again. I'll give you one opportunity this time to spend some time in jail. You have been cooperative with the system. I just ask you to be cooperative when it comes to bond conditions. And if there is some issue, just let her know if she contacted that she needs to make some alternate arrangements and not to have contact with you. Because what's going to happen next time you get picked up, you're probably going to be held without bond pending trial. And so that's kind of where we're at, and I hope just want you to understand that, okay?
Yes, sir, I do understand it, thank you.
Okay, I'll go ahead then and, just as we've indicated, impose the 3 days, as a violation of the bond, and then, hopefully, you understand where the court's coming from, if there are any additional violations, all right?
Yes, sir.
All right, continue to report to Ms. Smith that she directs pending trial, and, we'll, see you for trial, okay?
All right, thank you, Your Honor.
All right, all right, we'll go ahead and adjourn. Attorney Drake, do you have anyone else here today?
Yeah, this is kind of, pre-trial.
Yeah.
He's here, Your Honor.
Yeah, and is he here?
Yeah, he is. He's coming up right now.
All right, we'll go on record then in file 25, 10267FH, People State of Michigan versus James Richards Kinga. And Attorney Ronnie, I believe you're probably handling this matter, is that correct?
It is, Your Honor, thank you.
All right, this matter is on the court's docket for a pretrial on some flame looting charges, CCW, some R&O charges. We are scheduled for jury trial on May 19th, and a final settlement on April 4th. Has there been any resolution or any offers to convey for the record?
There has not been a resolution to the case, Your Honor. The offer was originally conveyed, I believe, prior to the preliminary examination in district court. That offer remains the same. I don't think there's any need to put that offer on the record at this time. It's our hope to reach a resolution before the final settlement conference.
All right, Attorney Drake, anything we need to address on a preliminary basis from your standpoint on behalf of your client?
Not today, not for the pre-trial, Your Honor.
All right, Mr. Sekenga then, we've got you listed at 353 South Street in Marcellus. Is that still your current address?
Yes.
Okay, and an emergency phone number if we have to get a hold of you?
Area code 269-251-8410.
All right, we'll go ahead then, continue your matter scheduled for trial. We'll continue your bond status previously. Already stay in contact with your attorney. If there is some resolution prior to the jury trial date on May 19th, he'll get you in court earlier than that date. If not, you'll need to be prepared and ready to go to trial on Tuesday, May 19th at 9 in the morning, all right?
Okay.
All right, we'll go ahead then and adjourn, and your matter, you're free to leave the courthouse. Attorney Kardasky, are you here?
Yes.
All righty. Do we have Mr. Van Diver?
Yes, sir.
All righty. We'll go on record in file 25-10266FH, People State of Michigan versus John David Van Diver. Mr. Van Diver's case is on the docket for a pretrial hearing this morning on some firearm charges, one assault charges, felony firearm charges. Attorney Ronnie, I'm assuming you're handling this matter as well?
Yes, Your Honor.
All right. This matter then, we just find out if there's been any resolution from the prosecutor or any offers conveyed today for the record.
There has not been a resolution, Your Honor. Mr. Kardasky has informed me that his investigator has some information that he's going to be producing. We're waiting to see that information, and then once we do, we will discuss a possible resolution.
All right. Attorney Kardasky, anything? Sounds like you've already done some discovery. You've got some information for the prosecutor. Anything else we need to address with the court?
Not at this time, Your Honor.
All right. Mr. Van Diver, then let me just ask you, we do have an address for you of 58438 County Road 29 in Goshen. Is that correct?
No, sir.
What is your address?
17358 Lakeview Drive, Vandalia, Michigan.
All right, and what is a phone number we need to get with you in an emergency?
260-977-9325.
All right, stay in contact with your attorney. If there is a resolution, he'll get you back before your jury trial date, which is scheduled for May 19th at 9 in the morning. If there is a resolution, he'll get you back, so stay in contact with him before that date. If there is not a resolution and the matter reached, then make sure you're ready and prepared to go to trial on Tuesday, May 19th at 9 in the morning, all right?
Yes, sir.
All right. Anything further, counsel, in this matter?
No, Your Honor. No, Your Honor, thank you.
All right, we'll go ahead and adjourn. Yeah, Attorney Kardasky, did you have anything else this morning, or this afternoon, in the court?
I had Justin Zeitler in the jail, but it's, doesn't appear to be Mr. Zeitler that is on the
No,
screen.
that's Mr. Hunter. Why don't we go ahead, get Mr. Hunter back, here, Mr. Hogue. All right, we'll go ahead and call file 25101998, State Michigan versus Kemper, Alan Hunter. Mr. Hunter's case is on the docket. I was here today on a motion for adjournment based on a request by Attorney Hogue. He said he was going to file a suppression motion with the court by next Monday in this matter. Mr. Hunter obviously is in custody at this point in time, so I did inquire if he had any objections to the adjournment. It sounded like Attorney Stecker was prepared for trial. Is that correct, Attorney Stecker?
For trial.
All right. Then Attorney Hogue, then you did have a chance to speak with Mr. Hunter, is that correct?
Yes, Your Honor, we did go review the nuances of some of his questions and where we currently are with some of the underlying facts, Your Honor. And at this time, we would still request the court to consider the adjournment in both those files in the anticipation of resolving what we hope to be some of these files, either through motions or through negotiations with the people.
All right. Mr. Hunter, then you had a chance to give you breakout room with your attorney. Just let me ask again, any objection if the matter is adjourned, so your attorney can file a suppression motion with the court? All right. Well, I just make sure you understand everything and are comfortable with the decision. Your attorney indicated he can get that motion filed within the next week. I don't know exactly when we'll hear it. It may take us a few weeks to get it on the docket. From our standpoint, so there could be a few weeks where you're still in custody, but we'll try to get it scheduled since you are in custody as soon as we can, okay?
Judge, may I say something?
Go ahead, Attorney Stecker.
Your Honor, I'm somewhat confused. I was just sent a text asking if the plea offer was still open, and he was willing to plead. Now, it's my understanding he's not willing to plead. I just want to make it, if I can speak, I just want to make it clear that no offers will be made at this time, and we'll just be ready to go to trial once the court addresses the motion to suppress issue.
Very well, we'll be ready as well.
All right, then, we'll go ahead and adjourn, and again, if there are any further negotiations that have to check between counsel, the Attorney Stecker indicated that any plea agreements that were apparently previously placed, at this point in time, you were drawing those offers, is that correct, Attorney Stecker?
Yeah, they were made last week, yes, Your Honor.
Okay, all right. Anything further than Attorney Hogue?
Nothing else for this court at this time. Thank you, Your Honor.
All right, Attorney Stecker, anything further?
I have nothing further, Your Honor. I made my position quite clear.
All right. We'll go ahead and adjourn then. Go ahead, Attorney Hogue, if you prepare a motion or an order.
I will, Your Honor. Thank you.
All right.
Ask a question, Your Honor, one question.
Oh, go ahead.
Mr. Stecker, what exactly was your plea offer?
I can't talk to you, Mr. Hunter. That's between you and your...
Right. Meet with Attorney Hogue. He can tell you what those offers were, and I guess, I again, and I don't know, again, I don't want to speak for Attorney Stecker, but if you discuss that with Attorney Hope, I mean, he's indicated that he believes that potentially the loss of larceny charge could be dismissed if he gets some evidence, I don't know. Again, nothing I'm privy to, I'm just here to hear the cases as they come before me. But I would suppose that you could discuss that offer with him, and if there was no motion filed, we didn't have to go forward with the motion, maybe Attorney Stecker would reinstate the plea offer, I don't know, I mean, if we didn't have to prepare and go, and I'm not, you don't need to give me an answer, Attorney Stecker, but it was just being discussed with Attorney Hope, he can let you know the nuances of it.
Your Honor, Mr. Holt is made aware of the offer from last week. I will leave that offer open until 3 o'clock today.
Okay, all right, so, Mr. Herndon?
He has the offer. He got the offer. There was a deadline last week. I don't know why he's smiling, but I made an offer. Got her back from him.
Okay, well, Attorney Hope, then you discuss the matter with Mr. Hunter, and then if there is a resolution, let Mr. Stecker know. I get it on my docket even this week, probably.
Thank you, Your Honor. I appreciate your time, and always, thank you, the people. I appreciate your understanding and willing to work together.
All right. Yep. We'll go ahead and adjourn then, I guess we'll just kind of see, Attorney Feldman, I don't know if you have any of you've got the bulk of the docket, so I don't know, you've got anybody here that's ready?
I believe I'm waiting for the jail to free up, Judge, unless Mr.
Okay.
Wallace is showing up on Zoom. No.
I don't see that. We have Mr. Wallace yet?
Just appeared there was a writ done, Judge.
Oh, okay, there wasn't a writ done, then obviously he's, Michigan Department of Corrections.
Yep.
That would need to be, put back on the docket and then, get another writ, get a writ done.
Yes, Judge.
All right. And I guess from the jail, is Mr. Truelove in the jail?
He is, Judge.
Okay. Why don't we, if we can, get the jail, bring up Daniel Truelove?
Your Honor, I did request the jail to bring up Mr. Truelove.
All right. All right, we'll go on record in file 25-10001, FH, People say Mr. versus Daniel Christopher Trulove. Mr. Trulove, I see you there in jail. Can you hear me all right? Yes, sir. All right. Agent Browning, you're here in this matter, is that correct? We're here for sentencing?
Yes, Your Honor.
All right. I didn't have a written report. Did you prepare a written report?
Your Honor, I'm just going to give a verbal from notes from Agent Cornwall.
And that's fine. Attorney Feldman then, you're okay with proceeding with just a normal record?
Oh, yes, Judge.
All right. Mr. Trulove, you're here for sentencing here today on a probation violation. And what we're going to do is have Agent Browning give us his recommendations. What I'm going to do is then hear from your attorney, Mr. Feldman, and then I'll give you an opportunity to make any statement if you choose as well, okay? All right. Go ahead, Agent Browning.
Thanks, Your Honor. Mr. Trulove was sentenced to an 18-month term of probation, June 27, 2025. This is his second probation violation. The first one involved him stealing a water cooler, which resulted in no additional jail time, but that he completed Twin County successfully. He entered that on July 2nd, 2025. He's here today because he was unsuccessfully discharged from the probation center on October 21st, 2025. He had 16 write-ups while at the probation center, ranging from lying, stealing, missed programming, missed schedule, out of place, and assaultive behavior. He tried being on supervision and in public and wasn't successful. He was put in a program and was unsuccessful as well. Due to his continued non-compliance with probation, it's recommended that Mr. Trulove's probation be revoked and he serve a term of 240 days in the Cass County Jail with credit for, it looks like Agent Cornwall has down 41 days total on the probation violations, and then checking his PSI, it looks like he had 164 days credit, so it should be 205 total days credit, it appears.
All right, Attorney Feldman.
Thank you. I know in speaking to Mr. Trulove, he has informed me he wishes to go back to Sacred Heart and try to give that a better run than he did last time. He told me that didn't depend on what the court did in terms of his sentencing, but I think it shows a better place for his head to be at, that he understands he's got issues and he's got to deal with them. I've represented him several times, so I am hopeful that regardless of what the court does, Mr. Trulove is able to get back on the straight and narrow, try to find stable housing, get a job, and try to stay out of trouble.
All right, Mr. Trulove, anything you want to say on your behalf?
I really nervous about the verdict myself, and I realized after that I could be risking and talking to my family. I want to better myself, and I want to be a part of society that is good and have a life. And I'm tired of wasting my time. I thought I want to build myself up. I would really appreciate that chance, sir.
All right. Well, nothing prevents you from going to Sacred Heart. Even contacting going on your own, Mr. Trulove. I've heard the report, and it is again concerning the courthouse. It's your second violation. You've only been on probation since June of last year, and then as the report indicates, there were 16 violations in Twin County. And so I think the recommendation that's been set forth here today is reasonable. What I'm going to do then is revoke your probation. I will order you to serve 240 days in the Cass County Jail with credit for 205. And what you need to know, Mr. Trulove, when you get out, if you truly want to be part of your family's life and be part of the community, it's gonna be up to you. You can go and engage in services. There's nothing that prevents you from contacting St. Garbers. There's nothing that prevents you from contacting Woodlands and being involved in treatment there. So if you're willing to do that, that's what you need to do. If not, the likelihood is you'll probably see me back again. I prefer not to, and I'm sure you probably prefer not to see me back. I prefer you just be a good member of the community. But you're gonna have to make sure you take whatever efforts it is on your behalf, just to make sure that that you can have a quality life with your family. Okay.
Thank you.
All right. I will advise you to have the right to appeal your sentence or conviction here today. Mr. Trulove, do so. You could file an application for leave to appeal. If you want to have an attorney assist you in any appeal of this matter here today, you could request an attorney. If you cannot afford an attorney, you can make that request with the court within 42 days of today's date, and I would review that. If you qualify, we would appoint an attorney to represent you. All right. Anything further in this matter, Agent Browning?
Nothing further, Your Honor.
All right, anything further, Attorney Feldman?
No, Your Honor, thank you.
All right, Mr. Trulove, good luck, and again, get engaged in those services, because you know it's gonna happen. That's why you're here today. So if you don't make those changes, you're probably just gonna end up either in front of me or some other judge in some other court. It's gonna be that vicious cycle over and over and over until you decide to make those changes. So I wish you luck, and I hope you make the right choices.
Ask the question, how many days in jail do I have, does that mean, sir?
240 with credit for 205 days. It looks like 35 days. I don't know if you have any credits from the jail or not, but that's what you're looking at. Okay, we'll go ahead and adjourn that. And then, is Mr. Pompey in jail, Attorney Feldman?
He is not. He has advised me he was picked up over the weekend in Allegan. He was released a little bit ago, and he's trying to find his way down here. So I don't have him yet, but he is trying to get down here.
Okay, is Mr. Leader?
Mr. Leader is in custody. We're ready to proceed.
In jail, we could bring Christopher Leader up, and then while we're waiting for that, I do see Tara Literal. Can you hear me, Ms. Literal?
Yes, sir.
All right. We go on record, file 25-10116FH, People State of Michigan versus Tara Marie Literal. And Ms. Literal is here for the court via Zoom, represented by her attorney, Mr. Feldman. And
Judge, I think this is initial arraignment. I haven't spoken to Ms. Literal yet. I'm happy to speak to her before her arraignment.
I just assumed maybe it was you, but I would assume that we do have, the public defenders that are here on the first arraignments.
Yep.
Was there someone else assigned?
I don't know if Ms. Smith knew about Ms. Literal getting arraigned today, so I didn't get notice. I'm happy to do a quick breakout room after Mr. Leiter's plea.
Okay, Ms. Literal, hang on when we get who do we have from the jail?
That's a guard. Can you get Christopher Leiter?
I'm thinking.
Yep.
Judge, we already when we get Mr. Leiter taken care of, then we'll put you in a breakout room with Attorney Feldman, and he discusses that violation with you. Okay.
All right, thank you.
Judge, in the meantime, we are ready on Isaac Gomez with Attorney LeBray.
Okay, Attorney LeBray.
Good afternoon, Your Honor.
Good afternoon, we'll call file 23-10149, FH, People State of Michigan versus Isaac Angel Gomez. And, all right, we have a on record in file 23-10149, I believe, People State of Michigan versus Isaac Angel Gomez. Mr. Gamez's case is on my docket as a result of a request and summons for probation violation. Agent Browning is here in this matter and did file a violation from December 10th. Is that the violation that we're dealing with, Agent Browning?
Your Honor, we're dealing with, we have two, I believe. I mean, this is a pretty old case. There are two separate violations mixed in.
And we've got one from December 13th of 24.
Correct.
And one of August 11th of 25.
Correct.
Okay, and then I had noticed that you had we've done a petition and order just on the 14th regarding an extension of probation. So, and that didn't have anything to do with the violations, is that correct?
It did in the sense that his probation was scheduled to be completed last month, so in order to keep the case going, we extended him to get this process taken care of.
All right. Attorney LeBray, on behalf of Mr. Gamez, did you receive the probation violations in this case?
Yes, Your Honor.
And did you have a chance to discuss them with Mr. Gamez?
Yes, Your Honor.
Okay. And what's his position regarding the violations? Again, I don't know. I don't know if there were any criminal charges filed. I do notice that the one on December of 24 indicated that he had driven without a license. And then the violation that was filed on August 11th last year, again, dealt with same kind of things. He drove without a license as well. So they both dealt with different driving violations at different times. So do you know what your client's position is regarding violations?
Yes, Your Honor. We intend to, I haven't had an exact opportunity to speak with Mr. Browning, but I believe that the December 13th, 2024 probation violation will likely be dismissed, as I believe that that is the violation where he was charged criminally in Elkhart, but they subsequently dismissed that case. I could be wrong, but I'm pretty sure that's the instance.
Yes, Your Honor, and we would dismiss that violation since that charge resulted in a dismissal.
All right, so the probation violation of December 13th to 24, you're requesting be dismissed?
Yes, Your Honor.
Okay, and then let's address then the August 11th of 2025, Attorney LeBray.
Mr. Gamez did plead guilty to that violation, and so we would agree to saying that he did violate probation in that regard.
All right. Mr. Gamez, is that correct then? You intended to plead guilty to violating your probation again, driving without a license on or about June 14th, 2025?
Yes, Your Honor.
Okay, can you raise your right hand, sir? Solemnly swear or affirm out of telling the perjury, testimony you will give in this matter, not paying before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay. Your name is Isaac Angel Gamez, is that correct?
Yes, Your Honor.
And your date of birth, Mr. Gamez?
9/18/94.
Okay. Now, if I accept your plea today, I want you to understand you are on probation in this court on charge of operating while intoxicated, third offense, and that if you did plead, the court could revoke your probation here with the court and could sentence you to a term of incarceration up to 5 years in prison. Do you understand that?
Yes, Your Honor.
And understanding that, you still wish to enter your plea here today?
Yes, Your Honor.
Okay. Now, if I accept your plea, you'll have the right to have a probation violation hearing, at which hearing you would be presumed innocent until proven guilty of the charges by your probation agent, Mr. Browning, who will be represented by the prosecutor. They have the burden of proving your guilt at that hearing by a preponderance of the evidence. So you understand you're giving up that those rights by pleading here today?
Yes, Your Honor.
You're giving up the right as well to have the witnesses who accuse you of the charges to actually appear in court, testify under oath in front of you, and in front of your attorney, Mr. LeBray. You're giving up the right to have Attorney LeBray question or cross-examine those witnesses as well. You understand that?
Yes, Your Honor.
You'll also give up the right to present witnesses or evidence in your defense and to have the court issue subpoenas on your behalf at the request of your attorney so that you would have the opportunity to present a full and fair defense. Do you understand giving up the opportunity to have the court or the right to have the court issue those subpoenas on your behalf?
Yes, Your Honor.
You're also giving up the right to have in these proceedings to remain silent, not have your silence used against you, and be giving up the right as well to testify at that hearing on your own behalf if you wish. You understand you're giving up those rights?
Yes, Your Honor.
Let me ask you then, Mr. Gamez, has anybody promised anything to get your plea to these the violations here in this probation violation?
No, Your Honor.
Anybody threatening you in any way?
No, Your Honor.
Are you pleading in of your own free will because you believe you're guilty of a violation?
Yes, Your Honor.
Okay, I'm going to read them to you specifically in count 1 as that is on about July 21st of 2025. We've discovered you violated condition 5.0 of your probation when you drove without a license on or about June 14th of 2025. And in count 2, I about July 21st we discovered you violated condition 1, which is the violation of law, provision of probation, when you drove without a license on June 14th of 2025. So let me just ask you, did you drive without a license on about June 14th of 2025?
Yes, Your Honor.
And where was that at?
It's in Elkhart.
Okay. And at that time, you didn't have a driver's license, is that correct?
No, Your Honor.
Do you have a driver's license now?
Yes, Your Honor.
Okay, all right. And you actually pled guilty to that violation, and what was the sentence down in Elkhart?
Your Honor, if I might, couple of nuances, because Michigan and Indiana law differ in this respect. He had what they call specialized driving privileges in Indiana. It's not a driver's license, but it's a court-authorized restricted driving privileges that the BMV in Indiana respects and will uphold and allow a person to drive. He had one of those at the time he was pulled over, but he was driving his boss's vehicle, which did not have the interlock device that his vehicle had, and therefore that is the violation of driving, the violation of his driving privileges, and that's what he was found guilty of.
All right. And then you did actually plead to that violation in Elkhart, correct?
Yes, Your Honor.
And then what was the sentence or resolution in that matter? Did you get fines and costs, probation, what happened?
He's on probation, Your Honor. He's on community corrections, and he is suspended from any jail sentence at this time. He has 6 months of community corrections in one case, 6 months of community corrections in another. Should be finished up in about a year, and it's running consecutively to LaPorte.
Okay. All right, then let me ask you, Mr. Gamez, as to the violations on or about July 21st, 2025, discovered the violence definition 5.0 year probation when you drove out a license on June 14, 2025, and then count 2, the on or about July 21st, 2025, was discovered that you violated condition 1 of your probation when you drove that license on or about June 14, 2025. How do you plead to those violations?
Yes, Your Honor.
All right, I'll go ahead and accept your plea, find your hire voluntarily understanding made with the assistance of your attorney, Mr. LeBray, and made on any threats or promises you've indicated. Agent Brown, did you want to proceed with sentencing here today, or did you want a sentencing set over?
Today, Your Honor.
All right. What I'm going to do, Mr. Gamez, unless there's an objection from your attorney, I'm going to proceed with sentencing today, and I'll hear recommendations first from Agent Brown, and I'll hear from Attorney LeBray, and I'll give you an opportunity to make a statement. Any objection if we proceed with sentencing here today, Attorney LeBray?
No, I'm pretty sure I understand what is going to be the recommendation.
Okay. All right. Agent Brown, then go ahead and give us your recommendation, and we'll have Attorney LeBray and then Mr. Gamez from you if you choose.
Thanks, Your Honor. Mr. Gamez was placed on probation back on January 12th, 2024. At that time, he was given 2 years probation, 105 days in jail with credit for 105 days already served. Since that time, he has had a few arrests in Indiana for the driving violations. And just to kind of make it maybe a little more clear to the court, in Michigan we have driving without a license, which it sounds like that's what Mr. Gamez did. However, due to the number of prior convictions in Indiana, he actually pled to habitual traffic violator, which is a felony in Indiana. And the sentence, as Attorney LeBray indicated, was a suspended sentence on a 365 day suspended sentence, credit for 8 days. So the balance of that is served on Michiana Community Corrections. Other than his violations for driving, Your Honor, Indiana reports that he has done well on supervision. He reports as scheduled. He's been negative on all drug tests, alcohol tests, and he has paid all his fines and costs in full here to the court in this case, Your Honor. Based on all that, at this time, I would just recommend that we revoke Mr. Gamez's probation and give him the time served of 105 days with credit for 105 days. I feel that would be a better use of the court's resources, since he'll be on supervision in Indiana. He lives in Indiana, works in Indiana, and he's being supervised currently in Indiana for us. So that's my recommendation, Your Honor. Thanks.
Thank you. Attorney LeBray?
I agree with the recommendation, Your Honor. I would add that Mr. Gamez is one of those stories of the journey to sobriety, where you learn as you go along after tripping and falling multiple times. He's been on interlock device for over a year. He hasn't had a single violation. He's going to be continuing with that interlock device through Indiana, so that's going to be providing the sufficient safety to the public. We've got a hearing for his specialized driving privileges that we're scheduling currently, and he's also got the probation in Indiana in Elkhart that's going to be supervising him. Having multiple probations going on at the same time is likely to trip him up as well, as it does for most folks. So I agree with the recommendation and just request that we close up. Thank you.
Thank you. Mr. Gamez, anything you want to say on your own behalf?
Yeah, I do. I finally learned my lesson. I'm ready to put all this behind me, so the drinking and driving and all that stuff that's behind me. I'm willing to stay sober and move on and put this behind me.
All right. Well, Mr. Gamez, it sounds like when we hear from Agent Browning that there's not been any violations on the interlocks, been represented by your attorney as well. So maybe you have kind of grown up and learned as you went along and had the violations. Obviously, you got yourself in a situation, however, with a probationary term and a jail sentence actually that's been suspended down in Indiana, but could be imposed if you continue to violate. It sounds like you have a specialized license and that you have the ability to drive. It's just, you just need to truly appreciate that if your specialized license requires that you only drive with an interlock, that means you can't even drive in the course of your employment. So you'd have to have permission from a court in order to do that. So it sounds like, again, even in this situation, that you didn't appear necessarily that you were driving, under the influence or doing anything illegal. It's just you were driving in violation of that license, which was the interlock device. I do think it makes perfect sense. There's no reason for us to have you on probation. You're actually being supervised in Indiana because you live there. And as a result, you've got a probation officer signed down there anyway. So it would just be duplicating services. So I'm going to go ahead and adopt the recommendation of the probation agent. I will revoke your probation up here, and I will order you to serve 105 days in Cass County Jail with credit for 105 days served. And Mr. Gamez, it sounds like you've got things behind you. Just really pay attention to what you need. When you get this behind you, then hopefully you can move on and have a kind of a normal life. All right?
Yes, sir.
All right. I will advise you have the right to appeal your sentence or conviction. If you could not afford an attorney to represent you and wanted to appeal, you could have the court consider the appointment of an attorney on your behalf. I see that the bail there is provided you with the notice of appellate rights review. If you did wish to appeal the decision here today and wanted to request an attorney to be appointed to represent you, go ahead and fill one of those forms out, return it to me within 42 days of today's date, and I will review that. If you qualify, we would appoint an attorney at public expense. Obviously, if you wish to appeal, you're free to retain Attorney LeBray or any other counsel that you'd like. All right, anything further, Agent Browning?
Nothing further, Your Honor. Thank you.
All right, Attorney LeBray, anything further?
Nothing further, Your Honor.
All right, and Mr. Gamez, any questions for the court before we adjourn?
No, sir.
All right, good luck, sir, and again, just make sure you file that specialized license, because that's the way you're gonna potentially get your driving privileges restored. If you show that you can file that license there, that specialized license in Indiana, they grant it to you, then if you're compliant with that, then they'll look at expanding those privileges, all right?
Yes, sir.
All right, we'll go to adjourn. I do see Mr. Leader there in the jail. Are you Christopher Allen Leader?
Leiter, Your Honor.
Leiter, okay. I think that's what I said. Okay, Leiter. Yep. And Feldman is there. We'll go on record in file 2510157 FH. People say Michigan versus Christopher Allen Leiter. And let me pull your file up here real quick, Mr. Leiter. All right, and Attorney Ronnie, are you handling this matter?
I am, Your Honor.
All right. I'm showing on my docket that it is on my docket for a plea, and so if that's correct here today, then Attorney Ronnie, have you state the agreement for the record? I'll confirm that with Attorney Feldman and Mr. Leiter.
Your Honor, it's our understanding the defendant will be entering a plea of no contest to counts 1, 3, and 4. Pursuant to agreement, the people will move to dismiss the remaining counts. There is a sentencing component to this case. Your Honor, it's our understanding that the defendant is being admitted into a VA in-house program sometime next month. I believe Mr. Feldman has the exact date. So we're asking, with the court's permission, to adjourn the defendant's sentencing, or set it out a little bit longer than usual. We're thinking, 4 months?
Between 3.5 to 4, yeah.
Yeah, maybe 4 months from today's date. This would allow the defendant to complete the in-house VA program. And the sentencing component would be that he would be released from the jail to the program on the date that Mr. Feldman will notify the court. And if he successfully complies with all the requirements of the VA program that he's going to be entered into, then on the date of his sentencing, he would not be required to serve any more incarceration. Any probation would be left to the court's discretion. And the reasoning for the no contest plea, I believe, is lack of memory, Your Honor.
All right, and what are we using for no contest? Do you have an officer?
Your Honor, we don't. We'd ask that a PC sheet may have been sent over to Your Honor here this afternoon. It's a sworn affidavit from the officer that swore out the warrant. We've been unable to get an officer in this afternoon. I know one was at a funeral, and they were all night shift officers, so we had some difficulty. So we'd asked your bailiff if the court would accept a PC sheet, which I know the court normally doesn't, but this is a short turnaround with trial scheduled tomorrow. So we're asking the court to consider that.
All right. Court did receive from court staff the PC sheet, and it was submitted obviously together with the police report. And we did have the probable cause sheet that was attached to that as the final page. Attorney Feldman.
I have no objection to the PC sheet being used, Judge. That's a sworn document, so not that much different than the officers being here under oath. The date that the VA program would be able to admit him is February 26th. I don't know if he needs to be released on the 25th to travel to the location for the 26th. I can provide more information to both the prosecutor and the court to delineate exactly when that would need to happen, but he's been screened by the VA, met all the admission requirements, and that's the earliest they could get him in. I concur that the basis for the no contest plea is a lack of memory. I had a long discussion with Mr. Leiter on Thursday evening in advance of when we thought we'd be taking this plea Friday morning, and can confirm he has very little memory of the incident, in part due to severe PTSD from the military, and in part due to intoxication. I think he would have concurred in that as well. The balance of the plea is exactly what we discussed. And again, I will provide to the court notification from the agent that he can work with the VA. His last name is Ramirez, as to when he needs to be released to start the program on February 26th.
Okay, Mr. Leiter, did they indicate when you, what arrangements were made to get you into the program?
The VA said they were going to provide transport to that operation.
Okay, so they pick you up in the jail?
I'm assuming.
Okay. And we can put that in the order, that you can be released to, from the Cass County Jail for transport to the representatives of the VA. So we'll put that in court order so that the jail will have that. And then I would just make sure that Attorney Feldman, just that they call the jail, let them, give them some advance warning that they're coming, so they can be ready to be discharged or released to them, okay?
Very well, Your Honor.
Okay. Mr. Leiter, then, can you raise your right hand?
I write on the front, Your Honor.
Uh-oh. Well, let me just ask you then. Okay, do you solemnly swear or affirm under penalty of perjury that the testimony you give in this before the court will be the truth, the whole truth, and nothing but the truth, and help you God?
Yes, Your Honor.
Okay. You put your hand down. Mr. Leiter, I want you to understand, obviously, the charges that you're pleading guilty to, that count one charge is a resisting obstructing a police officer causing injury, and that is a felony state misdemeanor. That's carrying a maximum penalty of up to 4 years in the state prison, and or a fine of up to $5,000. The count 3 charge, which was wearing body armor during accept your plea, you'll give up the right to have a trial in those matters. You give up the right at that trial to be presumed innocent until proven guilty by the prosecutor's office of these charges beyond reasonable doubt. You understand that? You'd also give up the right to have the witnesses who accuse you of the charges to appear in court, testify under oath in front of you, your attorney, Mr. Feldman. You give up the right to have Attorney Feldman question or cross-examine those witnesses on your behalf. You understand that? You'll also be giving up the right yourself to present witnesses or evidence in your defense, and be giving up the right as well to have Attorney Feldman, request that I issue subpoenas on your behalf, and that I issue those subpoenas on your behalf so you can have produce those witnesses. You understand you're giving up the right to have the court assist you in that regard by issuing those subpoenas on your behalf? Okay. Now, when you enter a plea here today, I realize it's no contest plea, but I'm asking some questions. You understand you're giving up the right to have these proceedings to remain silent and not have your silence used against you? That's the right you would have at trial and in any proceeding before the court. You understand that? Okay. You're also giving up the right you would have to testify at that trial on your behalf if you wish to. You understand that? Now, when you plead guilty as well, I want you to understand, Mr. Leiter, that you do give up some of your appellate rights. When you plead guilty or no contest, you can still appeal a sentence or conviction of the court, but it requires the filing of an application for leave to appeal. There's no automatic right to appeal if you have a trial, and the issues you can appeal on are limited because it is a plea proceeding as opposed to a trial. So do you understand you're giving up some of your appellate rights? And then you're also giving up the right to later come back and ask that I set aside your plea based on some promise or threat that's been made to you that you've not told me about here today on the record. You understand that? So the agreement was that you plead those three charges I went over with you, that you would actually be released to go to the VA on February 26th. They were sentencing out. I think the prosecutor said 4 months. Do you know how long the program is at the VA?
I believe it's a 5-week program, Your Honor, and so we picked the number 4 months just to make sure that there would be no delays since he won't be able to start for 1 more month from today.
I think it's a 5 to 6 week program, Judge.
Okay. Okay. So it looks like we could even possibly get it set in 3 months? Because we got a month delay on a 5-week program?
Yes.
Okay. Why don't we try to get it set out 3 months? That way we get you back in for sentencing, see how you're doing. Mr. Leiter, and I guess if you're still in the program and they need it adjourned, we can adjust our schedule on the back end. I'd like to get you back in as soon as we can, okay? Okay. And then as prosecutor indicated, if you are compliant with that program or following their services, that when you do come back for sentencing, they'll request that there be no additional jail time, and that any terms of probation and length of probation will be left to the discretion of the court. Is that your understanding of the agreement? Yes, Your Honor. Other than that, any other promises that have been made to you? All right. Attorney Ryan, did I state all the terms of the agreement?
Yes, Your Honor.
And Attorney Feldman?
You have, Your Honor.
Okay. Let me, what I would indicate is the officer that did sign the PC sheet was also the investigating officer. Let me get back to that screen. And it was signed by Maya Steele. And for the record, Attorney Feldman, you have no objection to the court utilizing that PC sheet, is that correct? It was signed under oath in front of a magistrate by Maya Steele, and again, it was subscribed and sworn on July 23rd, 2025. No objection?
No objection, Your Honor.
Okay, and then Attorney Ryan, the basis of no contest plea, as Attorney Feldman indicated, is that because of intoxication, that Mr. Leiter could enter his plea as a result of just ask you, Mr. Leiter, obviously you discussed the matter with your attorney. On the day of the incident in question here, hey, were you intoxicated? And as a result, you don't recall a lot of what went on, is that correct? Okay. You have had a chance yourself to go over the probable cause sheet with your attorney, and you're not disputing that information is contained in there, is that correct?
Correct, Your Honor.
Okay. What I will do then is for the record indicate that the probable cause sheet does indicate that on about July 22nd, approximately 5:24, that the officer, when I see was dispatched to a weapons offense at the address of 2483 Casey Street, Niles, Michigan. The call stated that the defendant, Christopher Leiter, was possibly intoxicated with a firearm. So the probable cause sheet does indicate, obviously, as well, that you were intoxicated. Christopher Leiter was found seated at the incident with an AR-15 strapped across his chest. He was wearing a tan metal plate carrier. When deputies arrived on scene, Christopher swung the AR-15 rifle from his chest, swept the rifle barrel from his right to his left, directing it towards the ground and over his back. After deputies secured the weapon, detained Mr. Leiter, Deputy CO interviewed the witnesses and the victim, with the victim identified as Michael John Luttrell. He stated that he feared for his life when Christopher approached multiple people outside the residence with the rifle. Michael and Christopher racked the rifle. Michael stated Christopher racked the rifle and threatened to kill him and his dog. Michael also said he felt the rifle was loaded. At the time after it was racked, during the interview with the witnesses and the victim, he observed Christopher hitting the window of the patrol vehicle with his handcuffs. So, and then it does go on, indicate that the deputies did give you multiple clear demands to stop. Your behavior, you escalated, and Deputy Tom Wilson, obviously Maya Steele, and Sergeant Ryan Shields had eventually put hands on you because you were actively resisting the deputies by pulling away and bringing your arms towards the center of your chest, tensing your muscles, refusing verbal orders to stop the behavior. Within attempting to overcome the resistance, Sergeant Ryan Shields sustained injuries and sought medical services by Borges City Hospital. So when I review all that, which you've not contested based on your indicating, discussing that with your attorney, the court would be satisfied that there would be a sufficient basis, factual basis and jurisdictional basis to support the allegations of the charges to which you pleaded guilty to. So I'm going to ask you then, I'm going to read the charges individually to you, Mr. Leiter, and then ask you as you plead. As to that count one charge on or about July 22nd, 2025 in Howard Township here in Cass County, in count one, you did assault, batter, wound, resist, obstruct, oppose, or endanger Ryan Shields, a sheriff or deputy sheriff of county task that you knew or had reason to know was performing his or her duties, and that caused bodily injury, requiring medical attention or medical care to that person. How do you plead with that charge? Okay. As to the count three charge?
It should be no contest, Your Honor.
Okay, no contest.
Thank you.
Okay. As to the count three charge, then Mr. Leiter, on or about July 22nd, 2025 in Howard Township here in Cass County, that you did commit the crime of commit the crime of felony assault, which involved a violent act or the threat of violent act against another person while wearing body armor. How do you plead that charge? No contest? Okay. And then the count four charge on about July 22nd, 2025 in Howard Township, Cass County, you did assault, batter, wound, resist, obstruct, oppose, or endanger Maya Steele, a sheriff or deputy sheriff of county Cass that you knew or had reason to know was performing her duties according to Michigan law. How do you plead with that charge? Okay. I'll go ahead and accept the plea for the reasons I set forth on the record earlier. Your plea is voluntarily and understanding made. It's made with the assistance of your attorney, Mr. Feldman, and it's made pursuant to the agreement he can be released from the jail to the VA staff. So if they came on the 24th, you'd be able to go if they made arrangements for you. I just have one question, Attorney Ryan. Honestly, when I look at the injuries, and just so that Mr. Leiter would know, it is possible, Mr. Leiter, that the court would be required, based on the fact that there was physical injury, to order restitution in this matter. I know it wasn't made part of the agreement, and Attorney Ryan, I don't know if there is any restitution that's been submitted or going to be requested, but based on the nature, I think Mr. Leiter should know that while it wasn't any of the conditions we want, I may be required by law to impose some restitution for the injuries. You understand that, Mr. Leiter? Okay, any objection to that? Okay, and Attorney Ryan, were there any figures that you have right now regarding restitution?
Your Honor, we have not had anything submitted at this point. I believe the injuries were relatively minor, so if there are some restitution requirement, we will get it to Mr. Feldman as soon as possible.
Okay, so at least there's not any right now, but come sentencing, there may be some minor medical bills that are submitted that just be required, and that would be obviously a term and condition of the sentencing as well. You understand that? Okay. Anything further than Attorney Ryan?
No, Your Honor, thank you.
Mr. Feldman, anything further?
Nothing further in this file at this moment, Your Honor.
All right, Mr. Leiter, do you have any questions for the court? All right, good luck, sir, and again, when you get out, I don't know where, let me just ask you real quick, since you're going into the program, they do have your address here listed at 2483 room 2, Yankee Street. I'm assuming you probably won't be returning there. Do you know where you'll be at? And if you're not sure, that's fine. Just make sure you get that information to Attorney Feldman and a phone number. He can get it to the court as well in case we need to contact you in an emergency situation, okay?
I'm gonna try to work something out with the VA, maybe you can stay up here if I have probation or something.
Okay, and they might even have a sober living home or something up there for you to live in as well. I don't know.
I'll try to find that out, Judge, and I'll also get his mom's information, because if they don't work that out, I'll probably be with his mom. So I'll provide that to the court when I get more answers.
And Agent Browning, I know you're on, do you have someone make contact with him up at the VA then to get some background information on the pre-sentence report?
Yes, Your Honor. If he's still there at the time, we need to do the pre-sentence report. We can make arrangements with that.
Okay, and so there may be some contact with probation with you up at the VA to get the pre-sentence investigation report prepared. And then obviously, Agent Browning, I would assume that if the VA made arrangements for him to be in Battle Creek, which would be Calhoun County, you'd probably be looking at transferring probation up there?
Yes, Your Honor.
Okay, so again, if they do place you, it's important that you let Attorney Feldman know that you keep the probation department informed, because we may need to transfer probation up to that county, so that they can supervise you up there, okay? Which would save you from having to come down here to report, those kinds of things, all right? All right, any other questions, Mr. Leiter? All right, good luck. We'll go ahead and adjourn. All right, and Attorney Feldman, I'm going to put you in a breakout room with Ms. Literal.
I'm on my way, Judge.
All right. All right, Attorney Holder, are you still around?
Yes, Your Honor. Pleasure of the court.
All right, do we have Ms. King?
She's in custody, Your Honor, but I did speak with her, and she's indicated that she does want to place responsibility on the record regarding the pending probation violation.
Okay, can we get Julie Marie King then?
And, Your Honor, I do have one other individual in the courtroom that won't take very long of the court's time. That's I believe Mr. Williams is in the courtroom. He's an individual that we also have.
All right, I think what I'll do, since I got Miss King, I'll take her real quick because we've got other people in jail. I'll get her out, and as soon as Miss King's out, we'll get Mr. Williams up while they're bringing the next individual in.
Thank you, Your Honor.
All right, so we'll call files 22-10037FH and file 24-10001FH, People City, Michigan versus Julie Marie King. Ms. King is president of the Israel Jail. You hear me all right, Ms. King? Okay, your attorney, Mr. Hogue, is present here in the courtroom. And the reason that we're here today, and let me pull these matters up. Is your probation agent did file probation request warrant for probation violation in both files. They were identical, filed by Michelle Cornwell and Agent Browning. You're handling these matters for Agent Cornwell today?
Yes, Your Honor.
Okay, and the violations in the files alleged in count 1 that you violated condition 4.25 of your probation, Your Honor, about July 17th of last year. You violated probation, you failed to report police contact, and then in count 2, you violated condition 1 when you violated Michigan state law when you drove without a license. You understand those charges?
Yes, sir.
Okay. Now, Ms. King, if I accept your pleas to the charges, you want to understand you are on probation in both those files on charges of possession of methamphetamine. And if you plead guilty to these matters, the court could revoke your probation and sentence you to terms of incarceration up to and including 10 years in the state's prison. You understand that?
Your Honor, I apologize to interfere here. Your Honor, there's actually 2 sets of probation violations. That probation violation that you just read off, that is a pending case that we have, and I would ask on that, those specific probation violations that we adjourn those. There's also another set that Agent Cornwell had submitted. Looks like there's about 6 counts on those probation violations.
Okay, and that was on October 16th?
That's correct, Your Honor.
Okay. In that one, and then the other one, so there's a pending, I would assume a DWLS file or something in district?
That's correct, Your Honor. It was just assigned to me.
Okay. All right, so in reference to the violation on 1-9, we can go ahead and adjourn that one. In reference to the violation on October 16th, and Ms. King, it does indicate that you violated condition 3 when you failed to report on September 3rd of 2025. Also, you violated condition 3.4 when you failed to attend MRT, which is the moral recreation therapy on September 16th of 2025. Also, you tested positive for methamphetamine on September 17th of 2025. You failed to attend substance abuse treatment on September 19th, 2025. And also, condition 2.0 when you violated probation when you possessed alcohol on October 13th of 2025. And then those are all non-technical violations. And then you had a technical violation in count 6 where you failed to report to your probation agent on October 7th or any time thereafter. Are those the matters you intended to plead guilty to? Okay. Can you raise your right hand? You solemnly swear or affirm on the perjury the testimony you will give in this matter now pending before your court, pending before the court, the truth, the whole truth, and nothing but the truth. So you got it. Okay. Put your hand down. Your name is Julie Marie King, is that correct? Okay. And Ms. King, what's your date of birth?
1977.
What was that again?
1977.
Okay. And now, if I please, as a mitigate, if the court could revoke your probation, sentence you to a term of incarceration for 10 years in each of those files, you understand that? Now, by pleading here today, are you giving up the right to have a probation violation hearing, and you're giving up the right to have those hearings to be presumed innocent until proven guilty by your probation agent, Agent Cornwell, who is represented by the prosecutor's office. You're going to have the right to be proven guilty of the violations by witnesses who accuse you of the charges to actually appear in court, testify under oath in front of you, and your attorney, Mr. Hope, being the right to have attorney Hope question or cross-examine those witnesses on your behalf. Do you understand that?
Yes, sir.
Okay. You also have the right to present witnesses or evidence in your own defense, have the court issue subpoenas on your behalf at the request of your attorney so that you have that opportunity. You understand that by pleading here today, you're giving up the right to have the court assist you by issuing subpoenas on your behalf for that hearing. Okay, you're also giving up the right to have to remain silent, not have your silence used against you. I obviously have to ask you some questions, so you're giving up the right to have these proceedings and at that hearing, that you have that hearing to remain silent. You understand that? And then you're also giving up the right as well that you have to testify at that hearing on your own behalf if you wish. You understand that? Let me ask you, Ms. Backus, or Ms. King, has anybody promised you anything against you pleading the charges?
No.
Anybody threatening you in any way? Are you pleading guilty of violation of your own free will because you believe you're guilty of those violations? I'm going to ask you some questions. You currently are on probation to this court, is that correct? Is Agent Cornwell your probation agent? And did you have a chance to go over a probation contract and sign one and understand the terms and conditions of your probation?
I believe so.
Okay. And your probation agent has alleged that you violated condition 3 when you failed to report on September 3rd. Is that correct?
I believe so. It's, a long time ago, but I believe so.
I mean, were you supposed to report to her like once a month or once every couple of weeks? Do you remember what it was?
Yeah, it was once a month. I don't know if I can take her heart or not. That's what he's waiting on those papers, but.
Okay. Did you also fail to attend, because they got different dates here? How long were you in Sacred Heart?
I was in there only for a week or so. The illness had come get me, and then I had a regret when the pills they gave me, and that's why I had gotten released from there. But I wanted to go back. I actually was like.
Okay, we'll get into that. You said for about a week?
8 days, I believe.
Okay. And then where did you go after that?
I was straight home.
Okay. And then were you supposed to, because the dates are spread out well over an 8-day period. Were you supposed to go to MRT as well?
I was supposed to go to MRT and I failed to do so because my wife had it out and I did not go.
Okay. And she also indicated on September 17th you tested positive for methamphetamine. So had you used the methamphetamine on about September 17th?
Yes.
Okay. And did you then fail on the September 19th as well to attend substance abuse treatment?
I really don't know what you're talking about that because I never was supposed to attend any other that I'm aware of. Any other substance abuse, I don't really like to talk about the MRT. I'm confused about that one.
Okay. I did know at the time of sentencing that I did order that you attend substance abuse treatment. So I don't know, again, what treatment may have been set up. I'm assuming, just for the sake of argument, that probably that upon your release from Sacred Heart, you were supposed to still engage in services locally. That would be my guess. Did you engage in these services when you were released from Sacred Heart?
I did. I went to their average care stuff, and they gave me some medicine too, and then I was also attending Woodlawn for over a year, with me.
Well, let me just ask Agent Browning some questions. Agent Browning, do you have, is there any notes that Ms. Cornwell has regarding the failure to attend substance abuse treatment?
Your Honor, from what I can gather in her notes is that that's likely due to her failing to complete the Sacred Heart, which was recommended. It indicates that she discharged herself on 10/7. So she was sent there to complete the treatment, but she did not complete it.
And is that correct then? You didn't complete the Sacred Heart program?
I did not come there. I put myself there, She never said me to anything like that.
I know, I understand, but she would have permitted you to go because of probation. Did you fail to complete that treatment?
Yeah, because I was, I had to go out on an ambulance.
Okay. Did you ever go back and complete the program?
No, I wanted to.
Okay, well, and then after that, did you engage in services at Woodlands or any somewhere else?
I did, with, the aftercare at, in Iowa,
Healing Center?
Something,
Riverwood?
Community health stuff, the community health there.
Community health, okay.
Yeah.
All right.
It's not that I haven't been trying, sir. I've been in a couple incidents, like I had restricted to their medicine, I was in the hospital, they had to, you know, and, I felt like I wasn't, like their classes, I felt like I couldn't take the classes, so I tried to release myself because I had, everything slowed up, I was delusional, and I felt like I wasn't getting anything out of it, so I wanted to get better and go back. Now, I didn't push myself into their late, it seems that you're.
Okay. Well, it sounds like based on what you said, that you did leave the programs because you didn't complete them because, you felt they weren't, beneficial. Is that correct?
Because I had that allergic reaction and I couldn't go to the classes.
Okay. Did you also possess alcohol on October 13th?
I did.
Okay. And, that would have been a violation. Did you also fail to report to your probation agent on October 7th or any time thereafter?
Yes, I did.
Okay, so, even if you were trying to engage in services, why did you report to your probation agent?
Because, like the first time that I went to, Sacred Heart and I released myself, okay, I contacted her on the way there, and, I had Mooney contact with her, that's where I was, and so did the facility. So, and then when I got out, I completely contacted her and went the next day to her, and then she put me in jail. I feel that Ms. Cornwell, she scares me, everything I try to do, she puts me under, you know, like, I'm not trying to disobey anything that she says or anything you guys.
Okay. All right, well, it sounds like you didn't report, you know, and she issued a pickup order, and when you did report, then she had you put in jail, is that correct? Okay, let me ask you, Attorney Hope, based on what you've heard, are you satisfied there's been a violation of probation, at least that, I mean, it appears on a number of them, at least possession of methamphetamine, possession of alcohol, failing to complete substance abuse, as she indicated that she discharged herself from those programs, and that she did fail to report until the day she was picked up. You satisfied?
Yes, Your Honor, I'm satisfied on actual basis for probation violation against the commission.
Okay. Let me ask you then, Mr. King, how do you plead to the violations of probation? Guilty or not guilty? What's that?
I'm guilty.
Guilty, all right. How about accept the plea, find it voluntary, and understand it may be made with the assistance of your attorney. In reference to sentencing, Mr. Browning, did Agent Cornwell indicate whether or not she wanted sentencing set out, or she mentioned going to Bear or River? I don't know what Ms. Cornwell might have planned.
Your Honor, Agent Cornwell did prepare a summary for me to make a recommendation for the probation violation sentencing today.
All right. Any objection, Attorney Hogue, if we proceed today?
Not at this time, Your Honor.
All right. Agent Browning, go ahead and give us the recommendation. We'll hear from Attorney Hogue. And then Ms. King, I'll give you a chance to make a statement as well.
Thanks, Your Honor. I'll kind of get to the conclusion first. Agent Cornwell is recommending revocation of probation. So I would just like to note for the court, if Your Honor would go along with that after I kind of indicate the reasons, that we would be able to dismiss the other probation violation for the driving while license suspended to get that taken care of.
Okay.
However, it looks like this is Ms. King's fourth probation violation. Her previous violations involved testing positive for methamphetamine while reporting for probation 6 times, failing to report on June 11th, 2025, and She had alcohol at her residence on June 18, 2025, along with a type of alcohol still in the backyard. For that violation, Ms. King failed to report to the probation office as instructed on September 3rd, 2025. She did a report on September 17th, 2025, and tested positive for methamphetamine. She tested positive on September 22nd, 2025, when she reported for methamphetamine as well. Ms. King failed to report on October 1st, 2025, but then called the agent on a video call. She was told repeatedly that a video report was not approved for her at this time due to testing positive on the 2 previous dates. Ms. King immediately said she was going to admit herself into Sacred Heart again. She admitted herself 10/6/2025. Court was scheduled for 10/7/2025. She discharged herself on October 7th. In the evening, she failed to report. After that, she had a spraying device on, but it stopped receiving information on October 3rd, 2025. Its location is unknown and it was never returned at this point. Ms. King has made a habit of not reporting testing positive for methamphetamine, then admitting herself into Sacred Heart, but discharging herself prior to completing the program, not reporting after getting out of the program, continuing to use methamphetamine, and not following the recommendation of Sacred Heart. She has repeated the cycle several times and then begging with the agent to give her a chance to get sober. Ms. King has made zero progress while on probation. She still owes $2,695.62 on both cases. She has a new pending charge for driving without a driver's license. She hasn't attended MRT. She hasn't completed any amount of substance use treatment that would benefit her. She continues to house various meth addicts at her home. She has absconded probation 3 times. She had an alcohol still in her backyard. She blames those who try to help her for violations instead of addressing her substance use disorders. Due to this non-compliance while on probation, it's respectfully recommended that Ms. King's probation be revoked and she serve 9 months, so 270 days in jail. And the credit would be 45 days in the 2022 file and 43 days in the 2024 file. And then, just for reading this, Your Honor, I would also just like to note that it appears Ms. King is now stating she wants to go to Bear River, which looks like this is her pattern. Obviously her attorney will probably ask for that. However, she can do that on her own once probation is revoked, if that's what Your Honor decides to do. But it appears, she has a habit of going to these and then discharging herself and then not following up. So I would stand by the recommendation. Thanks, Your Honor.
So what were the days credit? You said 43 in the
24 file.
Yeah.
And then 45 in the 2022 file.
43 and 45?
Correct.
Okay, all right. Thank you. Attorney Hall.
Thank you, Your Honor, and I think Agent Brown should probably go buy a lottery ticket because he's 100% right. I am going to ask my client to be able to be extended to actually get the services that are directly needed. I understand that she's been working with Woodlands to try to get admitted and approved for Bear Lake, which I believe, from my memory serves me right, is a 1-year program inpatient. I think this is something that she desperately needs. I think this is the opportunity the court has at this point, while having a jurisdiction and authority over her to send her there. And then, at that point, let her fully know that, look, if you don't follow through, these numbers that you just heard put out there are going to be more. I think at this point, because if we revoke her probation, we give her jail time, and she gets out, she's gonna be back in front of us in 6 months, 12 months, maybe 18 months, depending on how much jail time she gets. But I would rather at least put the ability for her to receive those services. I know she's been given those opportunities time and time again, but when I have someone sitting in front of me that's saying, I'm ready, then let's test her. Let's see what she's willing to do. Make her go into these programs and at least see where that can lead. Because if we don't, Ms. King is just gonna continue to get worse. And right now, she's saying and doing everything that we want to hear from her. And I know that's something that we hear quite often, and in all reality, maybe Mr. Agent Browning is 100% correct. Maybe this is her MO, and as soon as she gets a chance, she's gonna run from Bear Lake. But I think at this point, I think it would behoove all of us to at least put that caveat out there to see what help we can actually force upon Ms. King. And hopefully, that help will eventually be planted and something will grow and actually work for her instead of having steals in our backyard, getting probations for Matthews, breaking continuous laws. I think there has to be a change, and I'm hoping that this is the breaking point for Ms. King. Thank you.
Thank you. Ms. King, anything you want to say on behalf?
On behalf of I have tried to change myself and attack my defense how I got released from the Sacred Heart Reserve. Without my doing, I had to react to that one, had to leave my ambulance, and I was not right. And I just want to say that I want to do better, and I'm going to do better, and you think that this is the great thing. I know I'm wrong, I know I'm an addict, and I want to change my life. And just do what you can. Thank you.
All right. Well, Ms. King, I think what I heard from probation, obviously, is that obviously your fourth violation, we had a number of repeats with substance abuse, both alcohol as well as amphetamine. You have been unsuccessful at placement, and I think the recommendation is appropriate. I think as Agent Browning indicated, Ms. Cornwell, there's nothing that prevents you from seeking treatment on your own. So whether you're on probation or not, if you want to go to Bear River, that's something that you can explore. And so if you discuss that with Woodlands, you've made those arrangements, that's something that you can explore on your own. And I think based on the history here, you've got a 22 file, a 24 file, and we've been here, again, as the agent indicated, on a fourth violation. So I'll go ahead and dismiss the probation violation as it relates to the new charge, which is the new probation violation that was filed on 1/9/2026. And what I'm going to do, Ms. King, is I'm going to revoke your probation, and in file 24-10001, the court will already serve 270 days, Cass County Jail with credit for 43 days, and in file 22-10037FH will also order that you serve 270 days with credit for 45 days, and those violations and sentences will run concurrently. Ms. King, I will advise you have the right to appeal your sentence. Every patient here today to do so, you can file an application for legal appeal. If you wish to appeal and could not afford an attorney to represent yourself, you could request that the court appoint an attorney to represent you. Any request for counsel needs to be made within 42 days of today's date. I will review that. And if you qualify to appoint an attorney at public expense. Agent Browning, anything further?
Nothing further, Your Honor. Thank you.
Attorney Hogan, anything further?
Nothing else, Your Honor. Thank you.
All right, Ms. King, we'll go ahead and adjourn your case, remand you back with custody of Cass County Sheriff to serve the balance of your sentence. All right, Ms. Litterow and Attorney Calvin,
Yes, Your Honor.
you had a chance finally to speak with Ms. Litterow, is that correct?
I did, Judge. We're ready to proceed.
All right, pull that file up here. We'll go on record file 25-10116F8, State of Michigan versus Sarah Marie Literal. And Ms. Literal is here in court, represented by Attorney Feldman. And again, we've got a probation request warrant for probation violation, request of summons for probation violation filed by Agent Michelle Cornwell, and Agent Brown is here on behalf of Agent Cornwell. Ms. Literal, you're now currently on probation according to charge of possession of methamphetamine, which is a felony carries a maximum penalty of up to 10 years incarceration in the state prison. If you were to admit the violation of probation or be convicted, the court could revoke your probation and sentence you to a term of incarceration up to and including that 10 years. Do you understand that?
Yes, sir.
Okay, the violations alleged that in count 1, you violated condition 2.4. On or about December 30th, you were in the presence of people who possessed methamphetamine, and in count 2, you violated condition 4.19 on or about December 30th when you were in contact with people who were violating criminal law by possessing methamphetamine. Attorney Feldman, you had a chance to discuss those with Ms. Literal, is that correct?
I did, Your Honor, after discussing that with her and the potential recommendations from DOC today, she's prepared to plead guilty to those charges, and I believe we can proceed with sentencing.
And is that correct, Ms. Literal, you intend to admit those violations here today?
Yes, sir.
Okay, can you raise your right hand?
Oh, wrong one. Sorry.
Do you solemnly swear or affirm under penalty of perjury testimony you will give in this matter not any court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, put your hand up. Your name is Sarah Marie Literal, is that correct?
Yes.
Okay, what's your date of birth, Ms. Literal?
12/15/82.
All right. Now, Ms. Literal, I accept your plea here today. You're giving up the right to have a probation violation hearing. And at that hearing, you're giving up the right to be presumed innocent until proven guilty of the charges by your probation agent, who will be represented by the prosecutor's office. You're giving up the right to require that they actually prove your guilt at that hearing by the preponderance of the evidence. You understand that?
Yes, sir.
You'll also be giving up the right by pleading here today to have the witnesses who accuse you of the violations to actually appear in court, testify under oath in front of you, and in front of your attorney, Mr. Feldman. You're giving up the right to have Attorney Feldman question those witnesses on your behalf. You understand that?
Yes, sir.
You'll also be giving up the right you have to present witnesses or evidence in your defense, and to have the court issue subpoenas on your behalf to request Attorney Feldman so that you could have that opportunity. You understand giving up the right to have the court assist you by issuing subpoenas on your behalf?
Yes, sir.
And by pleading guilty, you're also giving up the right that you have at a trial or a hearing in this matter to remain silent and not have your silence used against you, and or be giving up the right as well to testify at that hearing on your own behalf. So you're giving up even the right to remain silent, you can have that hearing or the right to testify. You understand giving up those rights?
Yes, sir.
Let me ask you, Ms. Literal, is anybody promising you to plead here today?
No, sir.
Anybody threatening you in any way?
No.
Are you pleading to these violations of your own free will because you believe you're guilty?
Yes, sir.
Okay, pretty straightforward. You are on probation to this court, is that correct?
Yes.
And,
Well, I got transferred to St. Joe County now. But yes, I was.
But you were placed on probation because you live in St. Joe County and got transferred there for supervision.
Yeah.
But you're still living on probation here, you understand that?
Yeah.
Yes, and that's why you're back here for a violation, because if there is a violation of probation, you come back to the court, even though you're supervised by a different agency, you understand?
Okay. Okay, yep.
Right. And did you have a chance to go over probation contract and your terms and conditions?
Yes, sir.
Okay. Now, your agents indicated that you violated probation when on count 1 on 2.4, you were in the presence of people who possess methamphetamine, and also in count 2, in violation of condition 4.9, when you were in contact with people who violated criminal law by possessing methamphetamine. So why don't you explain what happened in this incident on December 30th?
Well, I went to friend of mine, sister, he had just signed a lease to a new apartment that he was getting, and we went to check on the apartment, and there were people in it. I guess it was people that were the last renters, like their friends or whatever, and he had them leave, and then he had a friend of his go to Lowe's to get a new lock set for the door. While we were there waiting, his parole officer, the cop, showed up for some reason or other, and one of the people there had possession of that.
Okay, and that would obviously be a violation of your probationary term, correct?
Absolutely.
Now, I'm assuming that based on the arrest there, that was the individual that had the methamphetamine charged with possession?
Yes, I believe so, I would assume so.
Okay.
I was in jail at 5 days.
Okay, so you went to jail in 5 days, but you weren't charged? You weren't charged?
No.
Possession?
Absolutely not, I had nothing to do with it, no.
All right, I'm satisfied there's a basis, Attorney Feldman?
I am as well, Your Honor.
All right, let me ask you then, Ms. Literal, is that count one, they violated condition 2.4, when you're in the presence of people who possessed methamphetamine, and count two, you violated condition 4.19. I went on there about December 30th, you were in contact with people who were violating criminal law by possessing methamphetamine. How do you plead to those violations?
Guilty, Your Honor.
All right, please find the error voluntarily and understand me, and made, as you indicated, without any threats or promises. Agent Browning, Attorney Feldman said you're ready to proceed with sentencing today. Are you ready to proceed?
Yes, Your Honor.
All right. Why don't you go ahead then and give us your recommendations. I'll hear from your attorney, Ms. Literal, and I'll hear from your attorney as well, okay?
Thank you, Your Honor.
Okay, go ahead.
Your Honor, it appears Ms. Literal was placed, or actually released from jail on December 24th, 2025. And she was placed on probation November 7th, 2025. So she's fairly new to probation. So it's concerning that on December 30th, she was arrested for this probation violation. Essentially, the information from Agent Cornwell indicate Ms. Literal was at a drug house where over a pound of methamphetamine was recovered. She admitted to relapsing and stated she would test positive if tested. Since being released from jail, she's reported as instructed, and her drug tests have been negative. She's being supervised out of St. Joseph County, where she resides with her daughter and father. So I would just warn or give guidance to Ms. Literal that, she was in jail for methamphetamine, and then within a week of getting out, should have very easily been back in the same position, if they would have charged her with any of the drugs that were located there. So she's definitely got to do a better job of who she's associating with, where she's going, knowing her surroundings, all of those things. And if she does have a daughter, it sounds like she cares for her father as well. So she needs to be out there for those individuals. However, for this violation, we would just be recommending that her probation be continued and that she be given credit for 4 days in jail that she served once the violation was created. Thanks, Your Honor.
All right, Attorney Feldman?
Having spoken to Ms. Literal, I think she understands the error of her ways, Judge, and she's certainly aware of your explanation, what she's exposed to. I think this is a sound recommendation. I ask that the court adopt it, and I furthermore, Ms. Literal, be very, very careful who you're with, who you're around, because the recommendation is pretty fair right now that it can get out of control pretty quickly for you.
Ms. Literal, anything you want to say on your behalf?
No, I agree that I need to watch my people play some of the names better, because I don't want to go back down that path. That's all I gotta say.
All right. It's interesting that you say people, places, and things, because you were reading my mind. So obviously, you've had some treatment in the past, or been engaged in some services, and they talk to you about people, places, and things. What are you 43, is that correct?
Yes, sir.
And how old's your daughter?
22.
Okay. And do you also take care of your father?
She's my father, he's my ex-father-in-law, but yes.
Okay, how old
Yeah,
is
he
he?
got a heart attack. He's 64. But yeah, he was a truck driver and he had a massive heart attack, so.
Okay.
He's on the way to.
You're very fortunate, I can tell you that, if they found a think Attorney Feldman can tell you, when you get charged there, normally your minimum guidelines on those start around 19 months. And just because of the nature of the charge itself, you'd be looking at a prison sentence. So when you look at people, places, and things, hopefully this is a wake-up call for you.
Yes,
And I tell everybody, you know, do you know one person in your life, including yourself, whose life never got better with them? Okay, then you have to do what it takes to get yourself off it, because all that's going to happen is you're going to end up in situations over and over and over again where you're in court talking to a judge, myself, or some other judge, and again, it's a situation that where you get involved in a situation where there's quantities that would justify the distribution or the delivery. You'd be looking at prison sentences. And
yes, sir.
And so, you're relatively new to probation. We'll go ahead and continue on probation as recommended by probation. We'll give you 4 days in jail with credit for 4 days. I'm sure you didn't enjoy those 4 days, right?
No, none of that.
And how would you enjoy 2 years in prison?
I know, I understand.
And that's what you gotta always think about. And realize that people, they don't really care about you.
Right.
They pretend to be friends, but I assure you, see it all the time, that if they could pin it all on you and get themselves out of trouble, they would.
Yeah.
So when you're involved with those things, there are no friends. So you really gotta look at those people, places, and things. So I'll go ahead and continue on, as previously ordered on terms and conditions. Have you engaged in treatment?
Yeah, I'm already had an appointment at Pivotal. I'm just waiting for the second, part of the assessment so they can get me into MRT and IOP.
All right. Well, then just continue to report your agent as directed, continue to engage the services that they direct, and hopefully we don't see you back here again. And again, you get to be stuck in a situation like that, you could find yourself recharged and potentially looking at prison. So that's what we're in, okay? I will advise you to have the right to appeal your sentence or conviction. To do so, you can file an application for leave to appeal. If you could not afford an attorney to represent you, you could request the court appointing an attorney to represent you for any appeal. And to do so, you need to file a request for the court for an attorney within 42 days of today's date. I'm going to send you that information. I ask that you now examine the receipt of it, return a copy, and then return another if you wish to appeal. So where are you? Are you still residing at the address that was on the warrant?
It's
12016 US Highway 12 in White Pigeon?
Yes, sir. Yes, sir.
Okay. And the 269-257-8206?
Yes.
All right. With that, then, anything further, Ron?
Nothing further, Your Honor, thank you.
All right, Attorney Feldman, anything further?
Nothing further, Judge, thank you.
All right, Ms. Literal, any questions?
No, sir, I think I got it.
All right, we'll go ahead and adjourn then.
All right, thank you.
All right. Mr. Hogue, got Mr. Williams?
I do, Mr. Williams.
And this is Tommy Rebellion Williams, is that correct?
Correct.
All right. We'll go on record, 25-10043FH, State Michigan versus Tommy Rebellion Williams. Mr. Williams is in court, represented by Attorney Hogue. And pull your file up here, Mr. Williams. All right, we're here on a petition in order, a request for warrant for probation violation was filed on December 15th, court, we appoint counsel for you. And so Attorney Hogan get a chance to discuss the violation with Mr. Williams, is that correct?
I have, Your Honor, as before, the last time we were in court, there was a pending file, I believe, up at Kalamazoo County, that's still pending. My client has indicated that file is about to resolve, but it is still pending. So at this time, Your Honor, I would request an additional adjournment for this other pending file to resolve out. It does sound like it is getting close to a final resolution, but I would be asking for adjournment based off those reasons. Thank you.
All right. Mr. Williams, let me ask you, when's your next court date in Kalamazoo?
In March, I think in March.
I didn't quite hear that. What did you say?
In March.
Attorney Hope, what did he indicate?
Your Honor, I believe that he's trying to indicate that it's March is the next hearing date. I'm not sure what date.
Yeah, I heard March. I didn't hear, did you have a date or just in March?
Just in March, it sounds like, Your Honor.
Oh, okay, I
Your Honor.
didn't hear the date. Go ahead, Your Honor.
I did check with Agent Lee in Kalamazoo County today, and he did check the file on Mr. Williams, and Mr. Williams did enter a plea on January 20th to the carrying concealed weapon with a recommendation from the prosecutor for the Holmes Youthful Training Act, and his sentencing is scheduled for March 6th.
Okay, and Attorney Hogan, you're asking that we get adjourned until after his sentencing?
Yes, Your Honor, I would request that, and maybe in the meantime, we can have it correspond to be roughly about the same time after the sentencing.
Okay, Mr. Williams, what I'm going to do is, since you have entered a plea at Kalamazoo, and your sentencing is set, you said on March 6th, we'll just reschedule your matter down here sometime after March 6th, and then we can see what your terms and conditions are up there, and then make a determination what we do here. All right, anything further than Agent Browning?
Your Honor, he is on GPS tether, and I just want to make sure on, as far as how it's in the court order, is that a condition of bond, or is that now a probation condition?
Okay, I don't see the order appointing. Is he currently on tether?
He is, Your Honor. At his last court hearing, and like I mentioned, I'm not sure if it's a condition of bond or now a condition of probation, but that he be on tether once he's released from jail.
Okay, I don't see it as either.
Okay.
You said that, was it ordered at the last hearing?
It was, Your Honor, based on my recollection, and once he was released, he did go the following day to Kalamazoo and had that placed on. And they were just curious how long he needed to be on that for.
Okay, I would assume, if it was at the last hearing, it would have been a condition of his bond on the violation.
Okay.
Judge, it's in the memorandum of action.
Okay, geez, I must have pulled that up real quick and looked at it, didn't see it in there, so let me just see. What's the date of the memo?
114. I'm sorry, 112.
Okay, that's not showing up in mine unless I had one of the custom queries in there. Okay, yeah, it's in the other screen, it wasn't in my, queries. So memo action, yes, this shall report to probation, on release for placement on tether. So it was a condition of his bond.
Okay, all right, so we keep him on that for his next court date, then I assume.
Correct.
Okay, thank you, Your Honor.
With that then, Mr. Williams, we'll just continue on your briefing, all right? Attorney Holger, are you on Shane Williams?
Yes, I am.
Is he here?
I don't believe there was a writ for him, Your Honor.
What's that?
I don't believe a writ was sent out on him, Your Honor. I believe that he's currently in custody in an Indiana state prison.
Oh, okay, I wasn't aware of that, so, do you have any information on that? I see Attorney Stecker, is he, currently incarcerated in Indiana?
He is, Your Honor.
Okay, all right, so I don't know if we can really look for a pretrial. I suppose we can contact them and see if they make him available, for a pretrial. If not, you might have to just, retain him up, on an interstate detainer if, to get the matter resolved here for trial. Do you know what his sentence is down in Indiana?
Your Honor, I believe that this is from the date that he was arrested, it shows in our file, has been the date that he's been in custody with Indiana, with, I think, some similar charges that occurred down in Indiana across state lines.
Okay. All right. Okay, well, all we do is, get a reset and contact and see if we can, if they'll make him available for, pre-trial.
Your Honor,
Go ahead.
would that be okay if he's made available through Zoom, or would the court want him here personally?
No, Zoom's fine for pre-trial. Obviously, if we were gonna try him, you need to probably do a detainer request. Yeah.
I have been scheduled for jury trial on May 19th.
Correct. So we'll try to get it rescheduled in the next few weeks. For pre-trial, we'll make some contact and see. You know what the facility he's in, Attorney Stecker? Do you have it from you?
I don't, but Mr. Ryan, I believe, is looking right now, reading his mind.
We can pull it up anyway when we get it reset, see where he's at, or you guys, you don't have to do it right now. We gotta reset it anyway.
Thank you, Your Honor.
He was sentenced to a lengthy prison sentence in Indiana, 8 years, as of January 23rd, 2025.
Alrighty. We'll go ahead and adjourn in that one then.
Thank you, Your Honor.
Yep. Attorney Hogan, do you have anything else?
No, Your Honor, thank you.
Attorney Feldman.
Yes?
We have Mr. Zeigler.
Sorry?
Who do we have in the jail?
That's Mr. Coleman.
Mr. Coleman?
Yes.
All right, are you, Adam Wesley Coleman? Okay, and, here for sentencing here today? Why don't we go on record, 25-10127 East State, Michigan versus Adam Wesley Coleman. This matter's on the docket for sentencing. It was scheduled on Friday, obviously, the courthouse was closed, and so we have to hear on the docket this afternoon. Attorney Stecker, are you here in this matter?
I am, Your Honor.
All right, Attorney Feldman's here on behalf of Mr. Coleman. The court did receive and review a pre-sentence investigation report and a sentencing information report prepared by Agent Browning. Attorney Stecker, did you get a chance to review that information?
I did. I have had an opportunity to review it, Your Honor.
Any additions or corrections?
No, Your Honor.
How about you, Attorney Feldman?
Your Honor, I went over it with my clients on Thursday evening. We had a lengthy discussion about it. I have no recommended changes, other than I think I told him he had 0 days credit towards the 11 months. It's actually 3 days because the parole detainer wasn't placed until June 22nd, 2025. So they are recommending 3 days, Mr. Coleman.
All right, Mr. Coleman, is that correct? You had a chance to go over the report with your attorney? Mr. Coleman, did you have a chance to go over the report with your attorney?
Yes, I did.
Any additions or corrections?
No.
Okay. Attorney Stecker, any comments you want to make?
I do, Your Honor. First of all, every now and then, things get by us that certainly we don't see. In this particular case, we found out that we were off on the score, and I scored it because of the out-of-state record that we weren't quite sure about. The other thing, too, is that's why it's higher than we scored on in terms of the sentencing guidelines. We believe we're certainly going to stick by the agreement that was made with the 10 months, Killebrew. I believe he's on parole in Illinois, and certainly they'll address that situation with him. His record speaks for himself, but nonetheless, his record speaks for itself, but nonetheless, we're certainly asking the court to follow the sentencing agreement that was imposed between myself and our office and Mr. Coleman.
All right, Attorney Feldman.
Thank you, Your Honor. I had a number of different conversations with Mr. Coleman during the pendency of the case. The parole situation in Illinois is unfortunate for him. He understands now that it doesn't allow him to receive any credit towards his sentence. He did go out on bond for a brief period of time before parole picked him back up, and that's why he's in jail right now. I think it's a good opportunity to take advantage of the programming in the jail. He can learn ways to deal with the issues regarding methamphetamine that have plagued him for some period of time. He's got family here to support him. They are in the courtroom hoping to be able to see him, but understanding that he's over Zoom. He did provide a couple of letters, which I provided to the court and to the prosecutor to speak highly of his work ethic and his religious beliefs. And I think if he puts those in the forefront as opposed to the people that he might unfortunately be hanging out with, he'll be better served down the road to avoid problems like this in the future. I wish him the best of luck.
Mr. Coleman, any comments you want to make?
No, I really hope for some kind of program, something other than just sitting in jail and not in the same situation. We would be for some board or anything like that. I thought I was going to miss around it, so I thought I was eligible to go back to the beach, and then I didn't get, well, you didn't accept me for that, but I didn't take ourselves, I thought I was going to get a here, but, I mean, I guess it was a bit of my past. jail, you know, for everything that's happened. And, I think we got a program.
Like, I have that to speak to the judge.
All right.
Judge, his father's in the courtroom and he's asking to address the court regarding the sentence. I don't know if the court wants to entertain that or not.
No, I want to hear from outside parties.
No, he just said nothing to outside parties. Thank you, Judge.
Yeah. Well, in this case, Mr. Coleman, on June 20th of last year, you were passing your vehicle driven by Matthew Haynes. It was stopped in Mason Township approximately 2 p.m. for no license plate. While Mr. Haynes was searching for his wallet, deputies saw some controlled substances on the floor from your seat. The vehicle was searched and 2 cat syringes were located and a baggie containing meth was found in a Celsius Energy drink can. When you were asked about the drugs in the passenger seat, you said you didn't know what the officer was talking about. He then asked about the baggie that was stuffed in the front of your pants, and you did at that point admit it was meth. You were taken to Cass County Jail, and while you were being searched, they also found another clear baggie hidden in your underwear. Mr. Coleman, when I look at your case, look at your background, it's your 12th felony conviction, and you were on parole out of Illinois at the time of this offense. You're 45 years old, and you've been to prison in both Michigan and Illinois for aggravated drinking and driving offenses. You also have multiple new controlled substance convictions, and according to PSI, you showed up at your parole appointment on December 3rd with both methamphetamine and alcohol in your system. And when you were confronted, you admitted you've been using meth regularly while on parole. It's just not acceptable, Ms. Coleman. Time your plea, there was an agreement you served on, I thought it was 11 months, maybe it was 10-month jail sentence. When I look at your guidelines, the fact that you were on parole out of Illinois, being supervised in Michigan, and you continue to violate probation by using meth and alcohol, after reviewing the PSI, I can't agree to that sentence recommendation. This is the 3rd time that I'm sentencing you on felony drug charges. First, possession of cocaine in 2018. Then in 2024, for possession of fentanyl. Now here we are again in 2026 for sentencing on possession of meth charges.
Cocaine charges in 2018.
Pardon that?
Cocaine charges in 2018. But I guess you have a lot of history. I took myself to rehab for the first time ever last year, 2 different times. I've tried, you know, I understand your point of view. I'm trying to be better, but I did.
Mr. Coleman, you're Adam Wesley Coleman, right?
Sure.
Date of birth 11/3 of 1980? Is that correct?
Yes.
I sentenced you on June 15th of 2018 for controlled substance possession, cocaine less than 25 grams as an habitual offender second. And you were given 365 days with no credit. That's because you were on parole out of the state of Michigan at the time you committed that offense. So, you were sentenced in 2018. You know, you were given a plea and sentence agreement in the 2024 file, case for possessing fentanyl, of only 2 days because you were on parole out of Illinois. And the rationale of that would be that if you violated parole again, you probably would be returned to prison on the underlying case in Illinois. Well, here's two things that happened. One, you violated parole again when you committed this offense. And then two, it doesn't appear, according to PSI, that Illinois intends to violate your parole. I guess they're taking the position out of their state, out of their hair. Then when I look at that, you're sentencing in 2018, I sentenced you to a year in jail again for violating parole out of Michigan. Well, you don't get a third pass for continuing to violate parole. Your actions in the court's opinion do not in any way justify deviation below the calculated guidelines. You've been on parole in 2 states, you continue to violate. Now you state in the PSI, you stated here today that you want to get into treatment and work through your issues. When I look at the PSI, you were given an opportunity while on parole at a facility in Orange County, California. And you left before completing the program. And then continued to pursue your issues, not trying to get into treatment and work through them. Now, lo and behold, when you're facing again calculated prison guidelines, you've now seen the light and you want help. I see a lot of possible converts in front of you, Ms. Coleman, and I have a pretty good sense of who's serious and who's trying to pull the wool over my eyes. I'm not going to accept the sentencing agreement below the sentencing guidelines. Not for a habitual parole violator in 2 states. I'll agree with a sentence here today of 30 months to 15 years in prison. And if you can't agree with that, Mr. Coleman, I'll give you the opportunity to withdraw your plea and then go to trial on trial calendar on the original charges, including the habitual fourth enhancement. But I would note that you're being sentenced today as a habitual offender second offense. And if you want to discuss the guidelines with your attorney, you can, because if you go to trial, which is your right, and you're convicted as an habitual fourth offender, you'll receive a sentence, you'll not receive a sentence of 30 months, that's time sentencing, probably twice that, not more. But you'll not receive a sentence from this court today when I review your record and the number of times you violated parole. I just can't do it. I'm not going to agree to that sentence. The plea agreement was placed on record long before I had an opportunity to review your history here, and it's just not acceptable when I look at the fact that you're on parole, you violated parole in Michigan, you got a year from me, you got a 2-day sentence on another because of Illinois. I mean, when I look at it, I go, this is the 3rd time violating parole. I can't just do that again. So, you can talk with your attorney. I will agree to a 30-month sentence, which again is even not at the top end of your guidelines, which I think were calculated at 57 months, or 47 months. So I'm going pretty much smack dab in the middle. But if we end up at trial as the 4th, I think the guideline is 74 months on the top end, something like that. So, but I just can't go along with it with a jail sentence. So, I'll give you some time to talk Terry Feldman?
I'm ready, Judge.
All right, do you want to withdraw, please?
I can do breakout room, yeah, I'm ready for the breakout.
Oh, okay, I'm sorry, okay. We'll put you in a breakout room with Mr. Coleman.
Judge, is Mr. Kardasky still here?
Yes, he
I don't know if he had, does he have anything?
He's here.
Yeah.
Yeah, I have Mr. Zeitler, but he's also in the jail.
Yeah, so that's the problem, everybody's in the jail right now, huh?
I hear that.
Yeah. And who's on Moto G Stylus 5?
I believe that's Mr. Pompey.
Okay.
Yeah, this is Michael Pompey.
Okay.
Justice be served to the ability to issue warrant, is that an abs arrest, or let that?
Yep, that's fine, we're leaving, and I'm gonna go to the news station.
All right, Terry Feldman, I see you there. Maybe come in the courtroom.
You just walked in here. I want to hear the rest of my subject.
Sorry, Judge, I forgot to turn off my screen in there.
That's fine.
Mr. Coleman elects to have his plea withdrawn and have the case be set back in the trial calendar.
All right. Mr. Coleman, then what I will do is, give you the option to withdraw your plea, and we'll set the matter back on the court's trial docket on the original charges. With that, then we'll adjourn and, Mr. Coleman's case.
Thank you, Your Honor.
You're welcome. All right, we've got, Mr. Pompey, Attorney Feldman.
Yes, Your Honor.
It's Matt, he should've got arrested.
All right, why don't we go on record in your case, Mr. Pompey, file 25-10110 F8, people say the sheriff is Michael Cornelius Pompey. Pull that file up here.
You're muted, sir.
Oh, Mr. Pompey, it's like we lost you. Attorney Feldman, are you hearing Ms. Backus as well?
We already did Ms. Backus, Judge.
Or, I mean Ms. Miller?
Yes, I am.
Okay, is she in the jail?
She is.
Okay, we can let the jail know to have, bring Ms. Miller up, and, what we'll do is hopefully, Mr. Pompey will get back on, we can, get him taken care of, and then we can get Ms. Miller. If he doesn't, log back on, we'll go ahead and take, Ms. Miller while he's trying to get back on.
Very well.
Okay.
I apologize for the behavior in court of my client's family, Judge. That wasn't something the court needed to hear.
Not a problem, I kind of, expect that sometimes, and as long as they're reasonable about it, I guess we can deal with it.
I don't think they were very reasonable about it, that's why I'm apologizing.
Well, I understand, they were probably a little more, than they should have been,
Perhaps you didn't hear it all. Oh, there's Mr. Pompey.
yeah, I didn't hear everything they said. Something about going to the press, but it wouldn't be the first time people went to the press. Mr. Pompey, can you hear me all right?
Yes, sorry, my video got disconnected.
No, not a problem, we were kind of waiting for you, I figured you'd sign back on. We'll go back on, yeah, we'll get on your case, file 2510110 FH, P. State University, Michael Cornelius Pompey. Mr. Pompey is here available via Zoom. Your attorney, Mr. Feldman, is in the courtroom. Attorney Ronnie is here on behalf of the people. Mr. Pompey, I'm informed that there's a plea agreement in your case, so I'm going to have Attorney Ronnie state the agreement. I'll have that confirmed with your attorney, Mr. Feldman, and then I'll get that confirmed with you as well. Attorney Ronnie.
Your Honor, I first want to inquire, the court has in your file there the amended information that has a count of largely between $200 and $1,000.
Let me see. When was that filed?
It was this afternoon. I checked with your staff and they said it had been forwarded.
Okay, let me just pull it up here.
It's not through the file room yet, but it is in your email.
Okay, let me pull the email up here. All right, there we go. All right, I've got the amended penalty information. It does add a count two charge of larceny, 200 or more, but less than 1,000. So go ahead, turn around.
Your Honor, it's our understanding the defendant will be pleading guilty to that added count 2. Pursuant to the agreement, the people will move to dismiss the count 1 along with the individual offender notice. Furthermore, Your Honor, I don't think there's another file that is being bound over. It looks like it has not been assigned a certain court number yet. That file will be dismissed as part of the agreement. The district court number for the file is 25-1453-FY. I don't know if it's going to get a certain number before this is done or not, but that will be dismissed as well.
Okay, all right. So Attorney Feldman, pleading to the count 2, larceny 200 or more, less than 1,000. Dismissal of count 1 and habitual offender second notice, as well as file 25-1453-FY.
That's a correct statement of the plea, Judge.
All right. Mr. Pompey, did you hear the agreement?
Yes, Your Honor.
Okay, is that what you want to do here today?
Yes.
Can you raise your right hand? Do you solemnly swear or affirm under penalty of perjury the testimony you will give in this matter not pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you put your hand down. Your name is Michael Cornelius Pompey, is that correct?
Yes.
And Mr. Pompey, I show your date of birth, my records of January 3rd of 94, is that correct?
Yes.
Okay. Now, Mr. Montiel, I accept the plea that count 2 charge, I'm going to read that to you. It says on or about April 29, 2025, in Williamson Township here in Gas County, that you did commit the offense of larceny by stealing a walnut tree that belonged to William Little. The value of the property stolen was 200 more, but less than 1,000 contrary to Michigan statute. That is a misdemeanor in the state of Michigan. Carries a maximum value of up to 1 year in jail and or a fine of up to $2,000 or 3 times the value of the property stolen, whichever is greater. In order to impose that 3 times, I need to hold a hearing to determine what that value is. You understand all that, and info that with your attorney?
Yes.
And understanding the charge and the maximum penalty, you still wish to plead to that charge pursuant to the agreement here today?
Yes.
And before we proceed, Attorney Ronnie, was there any restitution in this matter that what needs to be addressed?
There likely will be a number that will need to be addressed, but the homeowner is actually out of state, and we haven't gotten a specific number from him yet.
Okay. What I want you to understand, Ms. Monty, is there wasn't part of the plea agreement stated on the record, but I want you to understand, based on the nature of the charge being larceny, that the court would be required to consider under the Vanderbilt Mortar Restitution Act to impose restitution. So, as part of the plea, I want you to understand that the court could order restitution to be paid as well. Do you understand that?
Yes.
And do you agree to that as part of the plea agreement?
Yes.
Okay. Now if I accept your plea to the charge, you would be giving up the right to have a trial, and that would include the right to have a trial by a jury. Do you understand that?
Yeah.
You'd also be giving up the right at that trial to be presumed innocent until proven guilty of the charges by the prosecutor, and be giving up the right to require that they prove your guilt at that trial beyond a reasonable doubt. Do you understand that?
Yes.
You'd also be giving up the right to have the witnesses who accuse you of the charges to actually appear in court, testify under oath in front of you, and be giving up the right to have Attorney Feldman question or cross-examine those witnesses on your behalf. Do you understand that?
Yes.
Now, by pleading, you'll also be giving up the right to present a defense. And what that would mean is the court would, at the request of Attorney Feldman, issue orders on your behalf called subpoenas. And I would issue those orders on your behalf so that you have the opportunity to present a full and fair defense. Do you understand you're giving up the right to have the court assist you in that regard by issuing those subpoenas on your behalf?
Yes.
You'll also be giving up the right you would have at trial to remain silent and not have your silence used against you. Do you understand you're giving up that right by pleading?
Yes.
And then you're also giving up the right that you would have as well to testify at a trial on your own behalf if you wish to testify. Do you understand that?
Yes.
Okay. And now, additionally, I want you to understand that if you do plead guilty, you do give up some of your appellate rights. You still can appeal a sentence or conviction as a result of a plea, but it requires that you file an application for leave to appeal. There's no automatic rights to appeal as if you had a trial. And the issues you can appeal on are limited because this is a plea proceeding as opposed to a trial. So while you can still appeal, you understand you do give up some of your appellate rights by pleading here today.
Yes.
And then you'll also be giving up the right to later come back and ask that I set aside your plea because of a promise or threat that's been made to you you've not told me about here today. Do you understand that?
Yeah.
So let me ask you, other than the agreement that was stated on the record and with the addition that I mentioned with the restitution, that agreement was confirmed by your attorney. You confirmed that agreement with me as well, including the restitution. Other than that, has anybody promised you anything?
No.
Is anybody threatening you in any way?
No.
Are you pleading then to this count 2 charge that I read for the record of your own free will because you believe you're guilty of that charge?
Yeah.
Okay. I'm going to take you back on about April 29th of last year. Were you here in Cass County, Bellini Township?
Yes.
And did you, on that date and location, commit the offense of larceny by stealing a walnut tree that belonged to William Little? The value of the property stolen was 200 or more, but less than $1,000.
Yeah.
Okay, I'm going to ask you a few questions. Did you know William Little?
No, I do not.
Okay, did anyone give you permission to take this tree? Was Mr. Little or anyone else?
Just William McCulley.
Okay, why don't you tell me the then let me ask you, did you, know at the time that William McCully didn't have any permission from the landowner to take the tree?
No, I did not.
Okay, did you believe that, you were, that you had the right to take it?
Yeah, he made it seem like we really had permission, yeah.
Okay, why don't you tell me the facts of the case, and, I'll ask you some follow-up questions, or have Attorney Feldman question you. Tell me what happened.
Well, basically, we went down the road and we got a log that was basically on the side of the road, and he said it was okay to take it in.
Okay, and where did you take it?
Well, we took it into, the logging place. I forgot what the name of it is. I can't think of it off the top of my head.
Let me ask you, what time was it that you went and picked this log up?
You said what?
What time was it when you went and picked this log up?
I think it was around noon.
Around noon, okay. And you went with how many other people?
I didn't go. I just happened to put the log on the trailer. I had to go help a buddy finish yard work, and I also had to report for probation that day. So.
Okay, so you're currently on probation?
No, my probation got revoked.
Okay.
I served 80 days in jail, and that was that.
Okay, Attorney Feldman, do you have any questions, Mr. Pompey?
Mr. Pompey, we've discussed this issue. You might not have been told by Mr. McCauley that the dog was stolen, but given the manner in which he possessed it and the manner in which he said he got it, you had an idea that he didn't come by it legally. Is that fair?
Yeah.
So you knew that it was something that you probably shouldn't involve yourself in taking it for sale when you knew that it had probably been obtained illegally, correct?
Yes.
There you go, Judge.
Okay. All right. With that, then I think I have a factual basis. Let me ask you, Attorney Ronning, do you agree?
Yes, Your Honor.
Okay. Let me ask you, Mr. Pompey, after the count two charges on about April 29, 2025, in Bellini Township here in Gas County, that you did commit the offense of larceny by stealing a walnut tree that belonged to William Little. The value of the property stolen was 200 more or less than 1,000 contrary to Michigan statute. How do you plead to that charge?
Guilty, yes.
Okay, I'll go ahead and accept your plea, find it is voluntarily and understandably. There's sufficient factual and jurisdictional basis to accept the plea as well, to made with the assistance of your attorney, and as you indicated, no threats or promises to get you down your plea. Do we have a sentencing date for Mr. Pompey?
February 17th at 1:30.
Okay. What I'm going to need you to do is report to the District Court Probation Department, and they'll prepare a report recommendation, and you'll be back on Monday, February 17th, and that will be on the 1:30 docket, correct?
Correct.
It's actually a Tuesday, Judge.
What's that?
It's actually a Tuesday, Judge.
Oh, that's right, because we have the 16th as President's Day, so it would be a Tuesday. Mr. Pompey, are you still at the 16973 Church Street, Marcellus?
Yes, sir.
And what's a phone number if we had to get with you in an emergency?
269-816-8651.
86 what?
8651.
51, all right. All right, stay in contact, Mr. Fellow, make sure you contact the probation department, and you get that information, Attorney Feldman?
Yes, Your Honor.
All right, and we'll see you back then on Tuesday, February 17th.
Okay.
All right, you can go ahead and sign off.
Thank you.
Thank you, Your Honor.
You're welcome. Are you Brandy Miller?
Yes, sir.
All right. Pull your file up here.
Ms. Miller, this is Attorney Feldman. Do you need a moment to speak to me before we go on the record?
No, I have no need.
Okay.
Thank you, Mr. Feldman.
You bet.
All right. If you have any need or to talk with him after, we arrange here, I'll give you that opportunity as well, okay?
Yes, sir, thank you.
You're welcome. All right, we'll go on record, file 23-10051FH, Beach State Mission versus Brandy Ray Miller. And, Ms. Miller, you're here, this afternoon on a, request for warrant for probation violation. And, you were, arraigned on that, and you were, appointed counsel on January 12th. So, Attorney Feldman, I would assume we had a chance to, discuss the allegations at least with her, and so what's her position here today?
I did, Your Honor. She was sentenced originally into, at least when I was involved in the case, into the adult treatment court. Unfortunately, she was not able to finish the adult treatment court. She left the program and left Twin County and was subsequently arrested down in Indiana. So I believe she's prepared to admit that today. She's already been removed from adult treatment court formally by Judge Renfro.
Okay. Ms. Miller, then, is that your intention to admit the violation contained in the petition?
Yes, sir.
Okay. I want you to understand, I know I advised you before, but you're on probation to this court, charged with possession of methamphetamine. By pleading guilty here today, the court could revoke your probation, sentence you to a term of incarceration up to 10 years. Do you understand that?
I do.
And understanding that you still wish to enter your plea?
I do.
Okay, can you raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you will give in this matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you put your hand down. Your name is Brandy Ray Miller, is that correct? What's your date of birth, Ms. Miller?
0930-1984.
Okay. Now, if I accept your plea here today, you will be giving up the right to have a probation violation hearing. Your agent in this matter is Agent Cornwell, being represented by Agent Larry Browning here this afternoon. But do you understand that you're giving up the right to have a hearing, and you're giving up the right at that hearing to require that your probation agent, who would be represented by the prosecutor's office, giving up the right to require that they prove you're guilty of the violation by preponderance of the evidence?
I do.
You're also giving up the right to have the witnesses who accuse you of the violation appear in court, testify under oath in front of you and your attorney, Mr. Feldman. You're giving up the right to have Attorney Feldman question or cross-examine those witnesses on your behalf. You understand that?
Yes, sir.
You're also giving up the right to have the court issue subpoenas on your behalf to request of your attorney so that you can produce witnesses or evidence at that hearing in your own defense. So the court will issue subpoenas for you if you wanted evidence or witnesses produced. Do you understand that? You understand as well that by pleading here today, I've got to ask you some questions. So you're giving up the right to have these proceedings to remain silent, not have your silence used against you. You're also giving up the right that you would have to testify at that hearing on your own behalf if you wish. Do you understand that? Let me ask you, Ms. Miller, has anybody promised you anything? You should plea here today. Anybody threatening you in any way? Are you pleading to these violations of your own free will because you believe you're guilty of the violations? Okay. Ask you some questions then. You are on probation to this court, correct? Agent Cornwell was your probation agent?
Yes, sir.
And you did have a chance to go over a probation contract and go over the terms and conditions of your probation?
I did.
And she's alleged that you violated condition in count 1, 9.34 when on or about July 28th of last year, you failed to complete Twin County Community Probation Center. Violated condition 9.31 on the same date, you failed to complete the adult treatment court program. And in count 3, on the same date, you violated condition 4.2 when you changed your address. When you failed to report a change of address to your probation officer. So I'm going to take you back to July 28th. Obviously, you were on probation with the court, correct?
Correct.
And you've been ordered into the adult treatment court program into the Twin County Probation Center?
Yes, sir.
And it sounds like you left that program, is that correct? Can you tell me why you left the program?
I was going through some things in my head, which I knew Nobody did anything to me, it was a good program, I just didn't feel it was for me.
Okay, and then what did you do, just leave the program then and not report to your probation agent, and not follow up with your case manager for the treatment court, is that what happened?
He signed out. Yes, sir.
Okay.
There's a walk-in right in by the front door where you sign in and sign out. I was going to get medication and I never returned.
Okay. Agent Brown, anything else you want me to inquire of?
No, Your Honor, thank you.
All right, satisfied, Attorney Feldman?
I am, Your Honor.
All right, let me ask you then, Ms. Miller, after the violation in count one, that you violated condition 9.34, around about July 28th, you failed to complete the Cook County Community Probation program. In count two, that you violated condition 9.31, around about July 28th, you failed to complete the adult treatment court program. And in count three, you violated condition 4.2, around about July 28th, you failed to report a change of address to your probation agent. How do you plead those violations?
Guilty, Your Honor.
All right. I will accept your plea on the hour voluntarily and understand were made with the assistance of an attorney, and sufficient basis for the pleas, to accept the pleas, and as you've indicated, there have been no threats or promises made to get you your plea. Agent Browning, did you want to proceed with sentencing today, or as a result of being out of the programs, did Agent Cornwell want the sentencing set over?
Your Honor, she did give me a summary to make a recommendation today.
Okay, Attorney Feldman, are you in agreement with proceeding today, or do you want sentencing either?
We're prepared to go forward, Judge.
All right. What I'm going to do then, Ms. Miller, I'm going to have the agent give a recommendation from the probation department. I'll hear from your attorney, and then I'll give you a chance to make a statement as well if you choose.
Thanks, Your Honor. Ms. Miller was sent to a 3-year term of probation, with adult treatment court being a condition of that probation on July 11th, 2025. Unfortunately, she absconded from the probation center, as she indicated, on August 12th, 2025. So she made it roughly a month when she decided the program wasn't for her, as she indicated. She's been removed or revoked from the adult treatment court program due to that. Agent Cornwell indicated that there was a case in Elkhart Superior Court 4, which I found this kind of interesting, but it indicates she appeared for an outstanding charge on August 12th, 2025, which is the date she left Twin County, so I'm not sure, but it sounds like she may have left the center and went to court in Indiana. I'm not sure, like I said, if that's 100% accurate, but she had another hearing on September 24th, 2025 in that case, and the judge found that she violated her probation in that file by failing to report. Her probation was revoked and she was sentenced to 76 days with credit for time served and released on September 24th, 2025. She failed to report to probation here in Cass County after her release from the Elkhart County Jail, as she has left the adult treatment court, absconded from probation here. It doesn't appear she is probation material at this point, as she's absconded for over 90 days. It's recommended that her probation be revoked and that she be sentenced to 240 days in the Cass County Jail with credit for 105 days already served. Thanks, Your Honor.
All right, Attorney Feldman.
Again, I'm looking at Indiana's My Case site, and I'm looking at the same material I think Mr. Browning's speaking of. Looks like the hearing journal entry was actually dated September 26, and she was given a year in Indiana Department of Corrections, 76 days for credit, plus some equal good time credit for 152 days. I think she did a little more time down in Indiana than just the 76 days, and I suppose Ms. Miller can speak to that. And I think that might impact what the court does and how much credit she may have if it's applicable. I know she made some poor decisions in the past. She recognizes she made some poor decisions in the past, but she spent a lot of time behind bars, and I think it's time to see if she can go out and prove herself that she can stay clean, get a decent place to live, get a job where she can earn a wage, pay rent, save to get a car, all the things that we all take for granted. So I would ask that the court look at the time she spent in Indiana and fashion something with a shorter sentence to allow her to start trying to see if she can do this on her own.
All right, Ms. Miller, anything you want to say in your own behalf?
I do, Mr. Harmon, I know our previous has not, it's been real rocky, and I understand that, and I get it, and I have shown some really incredible behavior. I sat 6 months in IDOC in Indiana. Now, when I sat those 6 months, I had a lot of time to think and a lot of time to figure things out. And I know I can do it. I know I can. And I deeply apologize for our rocky past. And I just wanted to say that to you.
Let me ask you, when you sat in IDOC and said you had a lot of time to think about it, why didn't you report back up here when you got out? Because you had to know that the authorities would be looking for you. So if you really wanted treatment, wanted help, and had thought about it, why didn't you report back up here and say, hey, I see the error of my ways, and I really want to help now? Why didn't you do that?
I was in Johnson County Jail.
No, but you said that after you got out.
When I got out, I was out for maybe 3 days. And I was put right into Johnson County Jail.
Okay. And then did you get transported from there up here?
I got transported from there to Elkhart County. Elkhart County sentenced me to sit all the rest of my remaining time, which I did. And I sat probably a few weeks extra of it. That's because they had to figure things out with you guys. No big deal.
And then did you get transported up here from Elkhart?
WT, Sheriff Bailey and Sheriff Johnson came and picked me up and brought me here.
Okay.
I was extradited.
Okay. Obviously, you wouldn't get any credit for the time you served on a valid sentence. I don't know, Agent Browning, if it shows if she was actually held down there upon release for any additional time.
Your Honor, the dates Agent Cornwell has are January 8th through today for the additional credit of the 21 days. Anything prior to that, I'm not positive on. However, I did just check the Indiana Department of Corrections website, and it showed her projected release date on that Elkhart County case was 1/8 of 2026.
And so that's the date that Agent Cornwell projected as well?
Correct.
Okay. All right. Anything else you want to say, Ms. Miller?
No, sir.
All right. Well, Ms. Miller, you've been on probation, you didn't stand from treatment court, you stand from a program, and it's a shame you didn't, because you indicated that there wasn't anything wrong with the program, it was actually a good program, not the program. Again, your guidelines here, you had jail and or prison guidelines anyway, they were what are called straddle cells, so, you were given that opportunity, initially. I'm showing, Agent Browning that she had 120 days credit at the time of the original sentencing, at least according to my sentencing report.
Yeah, let me double check, Your Honor. She had down 84 days, but I can double check that, see what we show.
And I apologize, I don't have that information because I didn't represent her on the underlying file.
Yeah, I don't have her file with me, unfortunately, Your Honor, but on the PSI that we have saved in here, it's indicating 84 days, but as you're aware, sometimes at the time of sentencing, that gets modified or adjusted based on additional information.
I think I do recall she asked for ATC, so they had to reconsider whether she could be brought in and have to wait a second.
We actually adjourned her sentencing. That's what happened. We adjourned her sentencing, Agent Browning, I think from, originally, I think my sentencing memorandum, we had originally had her scheduled for June 6th, and she got moved to July 11th. So we ended up with over a month more, so we ended up, I think, with 120.
Okay.
And so,
Yeah, 141 days then.
All right, what I'm gonna do, Ms. Norris, I'm gonna go ahead and, revoke your probation as requested by probation. I'm gonna order you to serve, 240 days with credit for 141 days.
Okay.
And, again, think about some of the things that you've got to think about, you have a little more time to think about them. You're 41, I believe, right? 40? You'll be 41 this year, right? Yeah. You're still young enough to have a decent life, as Attorney Feldman said, but you're also at a point that if you don't seriously address the concerns and your addiction, this is going to be your life over and over and over and over again. So I hope you take the opportunity to think about it a little more, you get yourself engaged in services. Nobody's life ever gets better with them. And all you'll do is, this will be your life over and over, and I know you don't want that. And so, really think about that and make the changes, okay?
Yes, sir.
All right. I will advise you to have right to appeal your sentence or conviction here today. To do so, you can file an application for legal appeal. If you could not afford an attorney to represent you on appeal and wish to appeal, you could request the court appoint an attorney at public expense. And if you did want to make that request, you need to make that request within 42 days of today's date, all right?
Sir, thank you.
All right. You're welcome. Agent Browning, any further?
Nothing further, Your Honor, thank you.
All right, Attorney Feldman?
Nothing further, Judge, thank you.
All right, do you have any questions, Ms. Miller?
I do not, thank you.
All right, good luck, and I'd like just want to tell you one more thing. Your guidelines here were 5 to 23. So if you get another felony, realize those guidelines, which are called straddle cells, means you can get a jail sentence, which I gave you today. Another conviction your guidelines may be prison. So you'll probably be looking at prison. So just think about that as well and realize that that's, where you're headed. I hope that gives you some added incentive to say, I don't want that for me. I want a better life. And so when I get out, I'm going to engage in services, okay?
Thank you, Mr. Chairman.
You're welcome. Good luck, man. All right. Let me see. Do we have anyone else here on the docket? Attorney Feldman, I got
Should have Justin Zeigler in the jail for.
Captain Heifler.
That's Mr. Kardashi's file, and he's right here ready to tap in.
All right.
Thank you, Judge.
Yeah.
How are you, Mr. Kardashian? Oh, just Andy.
I know Nick's keeping track. Nick, is this the last matter on the docket today?
It is.
All right.
Nick's voice got a little high there.
That's fine. After a whole afternoon, I'm surprised I still have a voice, so. Sounds good, Judge. All right, I'm feeling good. We had to get at least, we got way more than a foot of snow at my place. I wouldn't be surprised if we had 14, 15, it was just like it was before. I mean, it's just incredible. It didn't stop snowing until just before, 1 o'clock. It just snowed nonstop until this afternoon. Sun came out a little bit. It's horrible.
You should see the pictures I'm getting from friends down in Tennessee, though. Horrible.
Yeah.
They're getting hammered.
Well, they're glad we'll get a lot more ice because it was warmer, so it's freezing, snow's coming, they're getting, and they're probably getting a lot of ice. And, you ever been down there, they don't know snow removal like we do up here. And so you get on the streets down there and, they don't know how to drive in it, they're flying all over the place.
I agree.
I came through Atlanta one time. I left Orlando. It was like 68 degrees. When I got to Atlanta, it was 9.
Oh my gosh.
And there was an ice storm. I counted 75 cars off the road. People were passing me, and I thought, wouldn't you think that you look at a car from Michigan driving slow and I need to follow that guy? Well, they were passing me, giving me the finger. Next thing I know, I see him off in the ditch, and I finally stopped and got something to eat, and I said, don't you have snow removal down here? We did see one snow plow in the median tipped over full of sand.
Wow.
And they said they only had 2 snow plows in Atlanta. At that time, it was in like 96, 97. And I said, don't you have snow removal? They said, yeah, it's called sun. So down south, primarily, that's what they consider snow removal. They wait for the sun to come up. They had already canceled, this was on a Saturday, they had already canceled school for Tuesday.
Yeah, it's like Washington DC, if there's forecast that they're gonna get a half an inch of snow, they close everything, it's crazy.
So in Atlanta, they had closed anyway all the way through Tuesday. It was Saturday morning when I was coming through.
Well, your car was like a turtle and everybody else going by it was like rabbits and they ended up, you're like passing by, waving to them, hey.
Yeah. I was away and I was just thinking, wouldn't you follow a car from Michigan as opposed to trying to drive around it?
Yeah, it's like, who knows better? You or me, Yeah, good point. Crazy weather this year. It's a cruel winter.
It has been at my house, that's for sure. It's like when you see the snow, the lake effect snow, I think it goes right over my house. And it's been there like the whole time.
Yeah, my dad worked on Great Freighters, and the coldest it ever got out on the Great Lakes he was on Lake Superior and had the 70 below windshield back there.
True, yeah.
And it's like I have to put on a couple pairs of Carhartts.
Absolutely.
Yeah, it's crazy. I don't envy those people in the Upper Peninsula.
No way.
They're gonna have it.
Do we have an agreement in this case?
Yes. Your Honor.
Okay. Is there an amendment that's been filed?
That's not necessary.
Okay, just checking.
No, I need to double check or don't take myself on this one.
I called them, they said they were ready to.
There he is, I see him coming in.
Sorry, my bad.
All right. We'll go on record in file 25-10264FH, People State, Michigan versus Justin Taylor. Is it Zeitler?
Yes, sir.
Okay. Mr. Zeitler is present here via Zoom from the jail. You can hear me all right?
Yes.
Your attorney, Mr. Kardasky, is in the courtroom on your behalf. Attorney Secretary on behalf of the people. Some matters the docket for a pre-trial hearing. My understanding is that there may be an agreement in this matter, and if there is, Attorney Secretary, have you state that for the record?
Yes, Your Honor, thank you. It's my understanding that the defendant will be pleading guilty as charged. If successful on probation, then the prosecution will reduce the charge to a use of methamphetamine. That is my understanding of the agreement, Your Honor.
All right, Attorney Kardasky?
That is a correct statement, Your Honor. We will also be asking for treatment under 7411, although that's not part of the actual agreement.
Okay, all right. You heard the agreement then, Mr. Zeitler. You're actually pleading guilty to the charge. That charge is a felony in the state of Michigan, carrying a maximum penalty of up to 10 years incarceration and or a fine of up to $15,000. Now, the agreement is, I'm assuming again with the prosecutor's recommendation, that she be placed, that she completes probation satisfactorily, that they would reduce the charge to a use of methamphetamine, which is a misdemeanor. It's a 1-year maximum misdemeanor. Is that fine? Is that 1,000 or 2,000, Judge Decker?
2,000.
2,000. So they'll actually reduce it. So I'm assuming based on that they're not requesting any upfront jail time. Is that correct, Attorney Decker?
I don't know if there's no sentencing agreement at this time, Your Honor.
Okay, but with the probation, in fact, you're going to reduce it. I just assume that maybe you weren't going to recommend any additional jail time sentencing, but that's why I asked.
No, that's fine, Your Honor. Thank you.
Okay. But, so you understand the agreement, Mr. Zeitler?
Yes, Your Honor.
Okay. Can you raise your, you want to go ahead and do that? You want to go ahead and enter that agreement?
Yes.
Okay, go ahead and raise your right hand if you would, please. You solemnly swear or affirm under penalty of perjury, the testimony you give in this matter not pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay. You can put your hand down. Is your name Justin Taylor Lenny Zeitler?
Yes.
And Mr. Zeitler, our records show date of birth on you as January 21st of 2001, is that correct? Okay. Now, if I accept your plea here today, I want you to understand that you are giving up the right to have a trial, and that includes the right to have a trial before a jury, you understand that?
Yes, I do.
You're also giving up the right to have that trial to be presumed innocent, so proven guilty of the charges by beyond reasonable doubt by the prosecutor's office. You understand you're giving up the right to be presumed innocent until proven guilty by the prosecutor's office. You understand you're giving up those rights. You're also giving up the right to have the witnesses who accuse you of the charges to actually appear in court, testify under oath in front of you, giving up the right to have Attorney Kardasky question those witnesses on your behalf. You understand that? And you'll also be giving up the right to present witnesses or evidence in your defense. So when you have a trial, you can present a defense, and I will issue subpoenas on your behalf at Attorney Kardasky's request, so that you could have your witnesses or any other evidence subpoenaed in the court, so that you could present a full and fair defense. You understand you're giving up the right to have the court assist you in that regard by pleading here today.
Yes, I do.
You're also giving up the right you have to remain silent and not have your silence used against you in these proceedings. Do you understand that?
Yes.
And you'll also give up the absolute right to have to testify at that trial on your own behalf if you wish. You understand you're giving up that right?
Yes.
Now, in addition, I want you to understand when you do plead guilty, you do give up some of your appellate rights. While you can appeal a sentence or conviction as a result of a plea, it requires a filing of an application. There's no automatic right to appeal as if you had a trial. And because this is a plea proceeding, the issues you can appeal on are limited. So while you can still appeal, I want you to understand you are giving up some of your appellate rights by pleading here today. Do you understand that?
Yes, I do.
And then you're also going to give up the right to later come back and ask that I set aside your plea because of a promise or threat that's been made to you that you've not told me about here today on the record. Do you understand that?
Yes.
So let me ask you, other than the agreement we've discussed, the plea of the charge
No,
Did anybody threaten you in any way?
no.
Are you pleading guilty to these charges, possessing methamphetamine, you're going through well because you believe you're guilty of that charge?
Yeah.
Okay. I'm going to read that charge to you. It says on or about September 27th, 2025, Pocatello Township, here in Cass County, that you did knowingly or intentionally possess methamphetamine. So take you back to September 27th of last year. Were you here in Cass County, Pocatello Township?
Yes.
Where were we at?
I was on M62, the car crash that I was involved in as a passenger.
Okay. And at that time when you were involved in that crash, did you knowingly or were you knowingly or intentionally possess methamphetamine?
Yes.
Was it on your person or in the vehicle?
It was on my person.
Okay, so you knew that it was methamphetamine, knew that it was a controlled substance.
Yes.
Okay, I'm satisfied. Attorney Stecker?
I am, Your Honor.
Attorney Kardasky?
Satisfied, Your Honor.
Okay, let me ask you then, Mr. Zeitler, then, as to that count one charge on about September 27th, 2025, Pocatello Township, here in Cass County, that you did knowingly or intentionally possess methamphetamine, contrary to Michigan law. How do you plead to that charge?
Plead guilty, Your Honor.
All right, I will accept the plea, claiming it is voluntarily and understandably made. It's made with the assistance of your attorney, Mr. Kardasky, and there's sufficient factual and jurisdictional basis, as you've indicated, there have been no threats or promises other than the agreement that was stated on the record. What day do we want to set in for sentencing then?
February 20th?
Okay, I'm going to set your case for sentencing on February 20th, which is a Friday at 8:30 in the morning. And in the meantime, a probation agent will meet with you and prepare a pre-sentence investigation report, and you'll have a chance to review that report along with your attorney, prosecutor, and court. You'll have a chance also to address the court at the time of sentencing. Let me ask you just a couple of questions. We have a South Bend address for you. 22150 Deer Street, South Bend. Is that where you'd be living if you found out?
Yes.
Is that your home or your parents' home or
It'd be my parents' home.
your parents' home? And what's the phone number if we had to get with you?
It'd be 574-323-3561.
All right. Anything further after Mr. Kardasky?
Your Honor, I did file a bond motion. Mr. Zeitler has been incarcerated since November 18th in our jail. To my knowledge, he has no prior convictions for anything. It'll give us an expected guideline range of 0 to 6 months. He does have a hold in Indiana. He bonded out on Monday down there. They extradited him here on Tuesday, and then he ended up missing his hearing on Friday that same week in Indiana. In addition, he also the hospital missed a fracture in his arm from the accident that's been going untreated. Due to the low guideline range, we'd ask the court to consider a PR bond in this matter.
Let me ask you, Mr. Zeitler, what are your charges down in Indiana, and is there a hold on you? Will you be going back there if released here, or what's up with you?
So, in the United Possession charge, they were related to an overdose. So, with that, I did put on, so I have a failure to appear hold, which I'm not sure if it's possible to get arraigned over Zoom. Again, I can see police custody. I was transferred from one jail to another, so we have a stay in the matter. I also didn't get a chance to meet with my court-appointed attorney down there before I was extradited, so I wasn't able to really get the message out and say, I need to reschedule or anything like that.
Okay, well, the court should be accommodating if you were in custody here and couldn't appear, and your attorney can address that there. Any position of the prosecutor?
Your Honor, obviously the hold in Indiana is a concern. With that being said, certainly I leave the bond issue up to the court, but I mean, I don't know if he's going anywhere with everything going on in Indiana.
Okay. What I'm going to do, Mr. Zeitler, obviously you're a resident of Indiana. They Mr. Zeitler, you're, what, 20, just turned 24, turned 25? Yeah. You're a young man, you have so much life ahead of you. You know, I envy you in that regard. I wish I could go back and be your age, okay? Don't throw away the most precious gift that you have in that age, your youth. And so, I just want, you know, take what you need to get, these issues under, control, and, you know, give yourself a chance of having a good life, all right? All right. Now, what I'm gonna need you to do, because you'll bond out, you'll need to contact our probation department, and that's at 269-445-4404. I don't expect you to memorize that. Make sure you contact Attorney Kardowski. He can give you the information, because you'll still need to contact our probation department. My assumption is that they bonded you out in Indiana and you were here to hold because of that, they'll probably let you bond back out. Then you'll need to report to our probation department, set up an appointment, and go and do a pre-sentence investigation with court, okay? All right. Anything further, Attorney Stecker?
No, Your Honor.
Attorney Kardowski?
Nothing further, Your Honor.
All right. Mr. Zeitler, any questions in the court?
No, Your Honor.
All right. Good luck, sir.
So much.
You're welcome. We'll let you hear. And with that, I think that concludes the court's docket on the evening of Monday, January 26th.
I'm ready for dinner, Your Honor.
All right.
I'm ready to go shovel snow.
I'm ready. I hope you got a good snowplow.
I have a snow blower that normally works pretty good, but with this much snow, I'll probably have to do about